Maharashtra and Rajasthan. Recently, in December, he passed on. It was a gifted loss.
mention one matter, my lord, for this threat of dispossession, not in an acquisition matter. The single judge refused to consider that on the ground that at some point in time in the past there was an issue raised with respect to a mahazar. But now, my lord, there's a threat of dispossession. Your lordship consider having it, my lord, on any day in the next 3-4 days.
Fresh matter.
Fresh matter. I don't think it'll take too long, my lord. It's a short issue.
What is the urgency?
There's a threat of dispossession in an acquisition. Dispossession in an acquisition matter.
Yeah.
Right, I'm great.
I make one more mention, my lords. It's a matter where the syndicate members of the Rajiv Gandhi University had been nominated with a term, my lords. There was an interim order. There was an, my lords.
Today it is there.
No, my lords. This matter, this was syndicate members of Rajiv Gandhi University. The matter was reserved in January.
Yes.
The judgment was pronounced on 5th April, but released on Saturday, my lords. So I'm only praying because we had an interim order throughout the pendency of the petition. Any time before the
May.
my lords. I think your lordships are hearing the other one, which has gone to June.
Not reserved.
No. This is a fresh matter, my lords. This is a fresh matter. Judgment was released on Saturday. My lords, I was in charge. I'm moving it so that it comes before the vacation. We have moved it, we have filed it today because the judgment was released on Saturday by the learned single judge. That's why, my lord, there is because we were functioning as the syndicate members till.
Yeah.
Please, my lords.
Even my matter is also common.
Same. Which are mentioned. Permission granted. We listed it. So there is no
meaning it. It will not reach it.
Please.
Even my
this
lords, even my appeal, lords, is also arising out of the same order, lords.
There's an appeal that we filed against the order of the learned single judge against the decision saying that the respondents number 4 to 8 are placed above me, my lord, in the list of promotions. And hence, despite
if
Uma
it can
Devi,
wait, if it can wait after vacation, it may wait.
a date may kindly be fixed, my lord, anytime this week or anytime after.
That will give. That is 30th May.
Much obliged,
If
my
your
lord.
lordship confirm,
I'm moving my memo for withdrawal, my lords. The date is already fixed in this matter. So that
Withdrawal.
Withdrawal, my lords.
Day after tomorrow at 2:30.
Tomorrow, this is a date given matter.
Then there is on month of
My
June.
lords, there is an alternate remedy, my lords. I've also filed my
That's all right, but on memo, you cannot take because judicially date is fixed. Application, if you file, we will.
We've already filed the memo application for early hearing, my lords.
Get it posted that early hearing.
with your lordship
You can wait,
confirmation,
Mr. For there is nothing. You can pursue remedy, alternative remedy, despite the pendency of this petition. Nobody prevents you.
Hearing day after tomorrow for hearing on the application, my lords.
If it is given by judicial order, it will not change it. That is the only. Otherwise, there is no difficulty in listing, but if it is posted to a date by judicial order, will not change it like that. Yes.
With your lordship kind permission, my lord, fresh matters, my lord, the existing structures, my lord, already demolished. My lord, now standing crops, my lord, there is a threat to remove the standing crops. My lord, this is the order passed by the land tribunal has been set aside by the learned single judge, my lord. Pursuant to that, structure has already been demolished.
After vacation.
It's kindly fix some date, my lord. Some
Date will
urgency.
be
is there.
given, new file, it will be listed, all matters will be listed.
My
If you want date, then it will be 10th of June.
My lord, see,
lords, one matter, my lords.
my lords, medical education matter, my lords, admission matter. So, identical matter is listed today, my lords, at serial number 11. This may be taken up tomorrow, my lords. This is, in fact, we had moved matter. This was, office has given the date as 6/6, my lords. Serial number 11, this is also similar matter, my lords. It may be taken up tomorrow, my lords.
Wait till serial number 11 is called out.
Big matter issue towards this extension of age of superannuation to 65 years. We think this is what is hearing the matter. It will be tagged along. Full bench is on court was hearing the issue pertaining to the age of extension of superannuation to 65 years. Serial number 20 today's the same issue.
So once it is called out, we'll pass approval.
Tagged along.
Wait, when it reaches.
Wait.
My lords,
lord.
memo for posting, my lords. This, my lords, shortage of attendance is condoned, my lords, on the ground, my lords, of the ill health of the father, my lords. And the university has been directed to take admission.
This can wait after vacation.
My lord, this is an,
After vacation.
Any date after vacation.
Date will be given, give some date.
my lord, this is an contempt matter.
My lord,
Matter is disposed on 28/3 or 2024. In its final order, instead of typing single bench, it has been typed as division bench, my lord. We have filed an application for the correction, my lord.
No, refused. Yes, madam.
my lord, there's a PI with respect to 1,300 acres of forest land that has been taken up by Benami transaction.
It can also wait after vacation.
Any date after vacation.
Give some date, yes. It will be, in this start from the week of 10th. huh?
Fresh matter,
Next.
my lord. This is the case, my lord, the
Yes,
appointment
no, not break the line, yes.
My lord, this is an education matter related to the CBSE board, my lord. The trust has not been affiliated with the CBSE board.
This can
but
wait,
they-
affiliation can wait after vacation.
My lord, may a date be set, my lord?
Madam, date will be given all right. 12th of June.
Lordship, it is a matter of PAL, my lordship.
Yes, Mr.
This is the fresh matter, my lord. This is the appointment of presiding officer to the district and session judge Bagalkot. From last 5 years, that vacancy is there and pendency is more in the Bagalkot court. Only one court is functioning, my lord. That in the month of January, we have filed.
This
The
can wait like any.
finance department is not.
We can
granted.
wait anyway, court vacation is coming, na? After vacation. we'll wait.
After. No, don't, it will be listed. Not giving date, yes.
Lordship is a writ petition in the nature of PAL, my lordship, in this case. Last week, the government of Karnataka passed an order through the chief minister to transfer the one historical animal husbandry
This
hospital
also can,
in favor of so and so. Therefore,
Can
my
wait after
urgency, my
vacation.
lordship, therefore only.
no date will be.
Like
once-
within the election, they may supposed to transfer. The original department will be the.
We'll ensure that it is listed within 2 weeks of the reopening. Yes,
Contempt petition.
Any date, my lordship, in this case. 26th or 24th or 26th, my lordship.
pardon?
26th or 27th, my lordship, kindly list it.
Yes.
It is a heavy matter, my lordship, because in the 1800, in the 1800, 1800, the property was gifted by a person, the Nathuram Sindhe, the historical donor of the state. He gifted the land to the government for use of only for the welfare of the animal and husbandry, not for other purposes. Now the government use for this purpose, they propose to use for the purpose for gym, school and everything for the minority department. To go,
Similar matter.
My lord,
we
similar
have.
matters are there, my
We have
lord.
not given any interim order.
No, my lord.
Not
it's
given.
this-
notice is order in that.
That's what. No
Notice is
urgency.
order.
Let
So
us-
in this case, my lordship.
Identical
I
matter
produced-
had come
I
up, but
produced
they had
the-
moved and it was directed to be posted along with writ petitions, my lord.
Similar matter, my lordship, 26th, my lord, please, my
Not
lordship, in
possible.
this case.
Yes.
Contempt matter, not posted for more than 2 months.
What is urgency?
Compassion appointment.
After vacation.
Date.
It will list it. Give all dates, all memos, don't accept memo, post it without accepting. It will be listed, irrespective of whether you submit the memo or not, it will be listed.
The petitioners are the agriculturist, my lordship. They are hails from a small village. In their village, a small reservoir is there. The reservoir is not supported by any river or inflows, my lordship. They're totally depending upon the monsoon. Water level is also very low in the reservoir.
but the government has decided to release the water for the agricultural purpose. The publics and livestock are totally depending upon that reservoir water. Now, my lordship, by virtue of the government order, my lordship, though we have made several representation to not release the water, the government has released the water, my lordship. The underground water level is also totally drastically reduced, and they are suffering from drinking water in the surrounded villages also purely depending upon their villages.
Immediately, 28th May.
My lords, serial number 40, list 1, my lords, I appear for the appellants. My lord, there's some difficulty, my lords, today, my lords, I request that the matter be posted after vacation.
I appear for the respondents, my lord. Pray for a date to be given in the first week of June,
First week of June,
please, my lord.
6th June, 6th.
Serial number 73, my lord, I appear for the second respondent. I have informed the petitioner of 73.
Your Lordship, I appear as party in person in serial number 44. I request that it might be called out of turn and early, Your Lordship. The serial number 44, list 1.
Case number 73.
Contempt matter.
Yes.
Case number.
Way out of turn.
WP number.
I'm not sure if it might reach by the end of the day, Your Lordship.
No, it will reach. Why you are so pessimistic? 13%.
That is the government.
Yes, Mr.
One matter, my lords, a mining matter, my lords, despite of the direction by this honorable court, my lords, to consider, even after the lapse of 6 months, my lord, they are not considered. Hence, the mood, this writ petition seeking an interim prayer, my lord. A date may be given, my lord, with urgency. 90.
After vacation, during first week of.
First week. First week. 5th of June.
My lord, serial number 40. May I, my lord? Serial number 41, my lord. For the second respondent, I've been served a copy of the appeal last week, my lord. I may need some time to come on record and file my objection.
Lord, I appeal for appellant, my lord. Lord, I appeal for the appellant. Serial number 41.
I'm party in person, my lord. And
Sir,
I have a
one
disposed
submission.
contempt case.
Sir,
The
one-
accused is retiring on 30th of April. This April 2024. And my matter was disposed on 24th 11 with the submission that I can revive the case anytime if they are not complying. It's been 5 months. They have released all the pension benefits immediately of my husband on the order of the contempt case.
So you file contempt petition.
Yes, sir.
Where is that today? It is posted.
Neither they are giving me the medical card nor the.
You have to file something, the court master will guide you.
I have given a letter in the judiciary court already.
More, you bring it here.
Just get it, sir. I'm just getting it. I need 2 minutes time.
Seal number 42, before other bench. And permission for pronouncement of judgment, serial number 1, Mr. Dev Prasad Shetty.
Appeal dismissed.
Yes.
Hearing on application serial number 2.
Sir, one submission, sir, regarding one submission regarding serial number 65, sir. I am for advocate. I am.
Same person. Same. Son of is suspended. Which may be.
Serial number 2. I appear for respondent number 2, madam. Your lordships now have heard, my lord, my learned friend appearing on behalf of the appellant, and also the learned advocate general appearing on behalf of the Karnataka Power Corporation. I believe, my lord, the battle lines are fairly clearly drawn. The principal question, my lord,
They don't change anything. Inside. Yes.
the principal question, my lord, which I believe is now before your lordships for consideration,
Yes.
is really, my lord, whether the action initiated by the appellant is a bona fide action to promote public interest as apparently claimed, or whether it is really an action to promote their commercial interest. And it is my submission, my lord, that the action is to promote their commercial interest and not a bona fide public interest.
This is not public interest.
No, my lord, it's not. But what is professed to be told to your lordship repeatedly is that giving this lesser amount of time to submit a bid is unfair as it results in stifling competition. That, my lord, was the bone of their contention. And then it was pointed out to your lordships that having regard to the magnitude
According to you, tender promotes commercial interest.
Yes, according to me, my lord,
Not public interest.
no, not the tender, my lord, the action. The tender promotes public interest.
Action
The
of
bid,
tender.
the action initiated before this court.
But subject matter of tender is public interest.
Of course, my lord, there's no doubt. That, of course, my lord, I can't say no. Of course, the subject matter of the tender is, of course, public interest. But the action initiated before this court is really to promote their personal, private, commercial interest. And the machinery of this honorable court, especially my lord, Article 226, is being abused. The other questions, my lord, which turn upon the compliance with the requirement of Rule 17(2), really, my lord, pales into insignificance. And if I understand my learned friend rightly, my lord, he also said that
it has now ceased to be of much relevance. As an ancillary to the first question, my lord, that I placed for your lordship's consideration, would be as to whether the appellant at all has a locus to file this action. And it is my submission that they do not have locus, having regard to the fact that the admitted position is that without a E&M partner, whether it is by way of a consortium or whether as a supplier, they don't have eligibility at all. And all this submission, my lord, that has been made both before the only single judge, which in my respectful and humble submission has been rejected, and now repeated before your lordship, is at the instance of a person who
Why there is no locus?
My lord, because they don't have qualification.
Locus and rights have a fine distinction.
My lord, I would say, my lord, that they
One
don't.
may not right, but still have locus.
My
To
lord-
approach the court or file the petition.
My lord, in the instant case, my lord, they don't have locus.
So
for the
are you
reason-
trying to say that he has no right to approach the court?
My lord, I would say, my lord, they don't have a right to challenge in the manner in which they have done. They don't have the locus because they don't have the eligibility. If they had otherwise the ability, but because of a tender clause, they were prevented, my lord, I would say they have locus. But in the instant case, my lord, since they lack the eligibility, they don't have locus.
How do you presume that?
My lord, they admit it. I'm not presuming it. I'm not presuming it.
That is the contention that electromechanical and hydromechanical partner was not shown.
Yes, exactly.
We do not know that area is still to be.
No, my lord, they admit it. They admit it in the writ petition that without an electromechanical partner or a hydromechanical partner, they don't have the eligibility.
That can be a ground of non-joinder of a necessary party. There is, Supreme Court has differentiated the locus, as my lord has said now, and the non-joinder of a necessary party. That 58 Supreme Court,
Yes,
Rajia
ma'am.
Begum versus so and so, where they have considered this aspect, not with locus and locum, which you have taken from Roman law. They are different. There are judgments, at least BL Vadhera versus Union of India, etc. Locus is different. He has right to approach the court. Whether he will succeed or not is another thing.
That is a different matter.
That's what the Honorable Chief
My lord,
Justice is saying.
I understand, my lord, the point that is put to me. I understand the point. I'll modify my submission, my lord, in the light of what has fallen from your lordships. I would say, my lord, that having regard to the admitted ineligibility, the question is as to whether they can at all challenge a tender condition. The next submission I make to your lordships for consideration would be that this is a petition which is motivated. This is, of course, not flowing from the first proposition I placed for your lordship's consideration, that this is for the purpose of promoting their commercial interest. And there is a very vital circumstance. The appellant, my lord, has been in discussions even before the publication of the tender with the E&M manufacturers. And it is they who have prompted the appellant to take the position that we need 90 days. Now the question that's before your lordship is this something which is meant to make the appellant work out an acceptable commercial term with the E&M suppliers? And it is obvious. I showed your lordships a letter that they have addressed to the Power Corporation saying that I need this time for the purpose of settling a commercial term.
Which document?
Yes, my lord. I'll come to each one of them, my lord. I'll come to it. In fact, it is, since your lordships have asked me that question, my lord, it is at page 581. My lord, I have prepared, my lord, a short list of dates so that, my lord, it will be easier. May I have your lordship's permission to place it for your lordship's consideration?
Please share it with your
Yes,
counterparts.
Yes, my lord, it's been done. Lord, if your lordship will be kind enough to turn to page 521, no? Which is that 621 or 521, which you told me. Yes, yes. Huh? My lord, at page 360, if your lordships are kind enough, my lord. My lord, it is in, it is volume 3. Volume 3, my lord. At page 300 and.
It starts at 359.
My lord, it starts at page 359, volume 3. No, I got it. If your lordship will kindly turn to that letter at page 360, my lord. Lord, it is a letter addressed by the applicant. Your lordship got it, my lord. It's in volume 3 at page 359.
359.
359. If your lordship will be kind enough to see page 360. Paragraph number 5, my lord. As you are aware, and your lordship will kindly see, my lord, this is a letter addressed by the appellant to the Power Corporation. As you are aware, in a tender process such as this, public interest requires a wider participation of bidders to ensure healthy competition. Conditions in the NIT which would result in restricting and or disabling participation of otherwise capable and competent bidders would be unreasonable and contrary to public interest. We would humbly like your good self to revisit, review and modify the below mentioned key conditions. Clause 1, Clause 17 of Volume 1 of Part 3, timeline of only 18 days for preparation of submission of techno-commercial offer. A timeline of 18 days for the preparation and submission of techno-commercial offer has been proposed. However, it is crucial to acknowledge the extensive nature of a project of this magnitude, particularly when undertaken on a turnkey basis. On an EPC turnkey basis, preparation of a techno-commercial bid would at the very least entail comprehensive efforts and steps towards site survey and investigation, which for a non-local bidder to arrange for and complete can be estimated to take at least 15 days. Preparing a preliminary basic design, which can be estimated to take 45 to 60 days. Coordination with E&M and IIM contractors, HM contractors, I'm sorry, HM contractors, and soliciting their feedback for design of civil components, which can be estimated to take at least 90 days. So, my lord, additionally, will be necessary, which can be estimated. So, my lord, what they clearly say is coordination with E&M and HM contractors and soliciting their feedback for the design of civil components, which can be estimated to take at least 90 days. Therefore, this 90 days, this magic number of 90 days, which is also the prayer A in the writ petition, is solely because they want to coordinate with their E&M contractors.
So
it is purely.
This also reflects ineligibility.
This reflects, my lord, I would say more on the commercial aspect of this litigation, rather than, my lord, a bona fide exercise of a right before a court. And the question that I would place for your lordship's consideration would be as to whether the process of Article 226 can be used to promote a commercial interest in a bidding process. Yes, yes. My lord, maybe, my lord, that this tender condition giving this 18 days or 23 days or 21 days as the case may be, may harshly operate against the appellant. Let us assume that, my lord. But that it harshly operates against the appellant is no ground to exercise power under Article 226. Unless your lordships come to a conclusion that it operates harshly against everybody and that it prejudicially affects public interest and falls foul of Article 14 And if I may place that for your lordship's consideration, my lord, in fact, my lord Justice Dixit would point out to us every time, my lord, when we had the pleasure of opposing him in appearing against the center, my lord, Article 261. That is the standard, my lord, that is the minimum that has to be crossed if we are challenging. Full faith and credit must be given. Unless, that's the mandate of Article 261. Full faith and credit should be given. These are the opening words of Article 261. And if that is the position, my lord, in the Constitution, I ask myself the question, has the appellant in this case made out a ground for exercise of an extraordinary power under Article 226? My lord, this is not a case of existence of the power. Existence of the power not in dispute to extend the time or stipulate a time. That the power has been exercised, not in dispute. That reasons have been given for the exercise of power, not in dispute. The question, my lord, that is posed for your lordship's consideration is whether those reasons are sufficient.
Third one is very militantly disputed.
Yes.
By the other
That,
side.
my lord, is on the ground that it is a fabricated document. Reasons are there. My lord, it can't be said that reasons are not there. What is told to your lordship for the first time here is that that is an insertion. And I would say, my lord, that contention, my lord, requires to be.
They did not say fabricated, they did not
Yes,
use
my lord,
the word.
that's what you
Said
said in the.
subsequent insertion.
Very well. I will. That is serious enough. That is serious enough, my lord. Even if it is not fabricated, it is a serious enough allegation. It's a very serious allegation. In fact, it borders on fraud. That something was inserted later on into the government records.
But that contention is not nowhere. Except here in the.
Except here. Yes, sir. Yes, that is our defense.
It was argued by me. I did argue this. I did argue this before the learned single judge, not considered.
No, you have argued that, that's what you say. But in the pleadings which other day you read.
Not there.
It is, we can't say.
No,
It's
but
not there. It's
are you raising that or not raising?
Yes, my lord.
You're raising that.
Yes, we have raised it here. We have raised it before the single judge also. Only thing is,
Namely that it is subsequently inserted document.
yes.
Yes, without a pleading. My lord, I will assume, my lord, that my lord has argued it. I'm not going to dispute that
You are
position.
not saying it is fake.
Insertion. It was not there.
It is not fake. It is not fabricated.
Lord, I'm not saying it is fabricated. It was not there.
No,
It
no,
is
it
subsequently
is
inserted.
It was originally not there.
Correct.
Never that reasons existed. Then subsequently
inserted,
created and
At the
brought
time
in,
of- at the time
or it was a document available but subsequently inserted.
My lord, virtually it amounts to, my lord, the fabrication.
Pleadings are not.
Pleadings are, Mogha, PC Mogha calls them as evasive pleadings, to say the least. Anyway, you have argued, we'll come to that.
My lord, I will assume for the sake of argument that my learned friend has argued this before the single judge.
But they have taken up that contention.
Not in the pleadings before the single judge.
Even in pleadings, yet in 3 paragraphs, to that text, they have taken, but it can be argued that they are very, they are lacking in material.
My lord,
particulars, etc.
not on the question that this was inserted. No, my lord. No.
Naked eye. My lord, to the naked eye, 41 and 42. Please have a look at it. This, my lord, this is not there at all.
Anyway, we'll come to that. We'll come to it.
My lord, all that I'm saying is, I am not on whether my learned friend is right or wrong. I will show to your lordship that he is wrong. I am on the threshold that the plea that this document was inserted subsequently is not there. Without fear of contradiction, I can say it. And the question, my lord, is whether by way of an amendment in a writ appeal, a plea of this kind can be taken. And in fact, my lord, the Supreme Court has taken the view, and I place that for your lordship's consideration. A plea of fraud cannot even be taken by way of an amendment. Where is the question of taking a plea of fraud in a writ appeal for the first time?
You said plea of fraud cannot be taken by amendment to the pleadings.
Yes. Yes, my lord.
In no circumstance.
Yes, my lord. That's what the Honorable Supreme Court has said. I showed your lordship this judgment. 64 Supreme Court, my lord, give me that judgment. It can't be taken by everyone. Yeah.
Appears to have been loosened.
I'll give it to your lordship. I'll give it to your lordship. I'll give you the judgment. Even in a original pleading, by a plea of fraud cannot be taken by everyone. Lord, the question of taking that for the first time in the pleading in a writ appeal, I would say, my lord, is worse. Position.
No, after filing of objections or reply of subsequent pleadings. The
No, it was not.
the broad surface is there.
My lord, it is not as if this document is being produced in the writ appeal.
We are on your submission, not on the text.
My lord, that I will show to your lordship that judgment, my lord. If that plea was already there, it can be taken in appeal. If it is not there in appeal, in the original proceedings, it cannot be done by way of an amendment. Well, I showed you your judgment.
But appears to be, it runs counter to what Lord Edward Coke said centuries ago, which has been quoted in P. Chengalavaraya and Naidu.
Yes,
also.
Yes,
your
yes,
that judgment which you are citing.
Yes,
appears to run counter to this, and therefore.
But I will show to your lordship the judgment. I just ask the learners to get the judgment.
Meghamala, etc.
Give me the judgment.
Meghamala, Chengalavaraya, Naidu.
Okay.
So many judges.
I showed you. Yeah, my lord. I understand, my lord. And fraud vitiates all judicial acts.
It can be taken.
Yes, my lord.
Anytime.
Anytime. In collateral proceedings, you can take it.
That's what.
But there is a view, as I'm now canvassing for your lordship's consideration. In any event, my lord, that may become academic in the instant case, because there was no such plea at all taken in the writ petition, and they never even sought to amend the writ petition. It can't be. Yes, my lord. Yes. And it can't be, my lord, that Lord, a plea of fraud is such a serious plea. That's why, my lord, special provisions are made under Order 6 Rule 4 of the CPC in relation to plea of fraud. And the least is to...
Court can notice the fraud at any point of time.
My lord,
for the party, it has to be a foundational fact. That is what we were trying to submit.
Yes, yes.
The party, it has to be a foundational fact.
Yes, correct.
To put up or construct.
Of course, the court can. I mean, I don't think, my lord, I would canvass the proposition, especially in a 226 proceeding, that the court, even if it is able to see fraud, should say, sorry, nobody has told me, therefore I'm going to shut my eyes to it. I don't think I'm going to canvass that proposition, my lord.
It's all because we like to debate.
But that I'm not canvassing. I'm saying, at the instance of a party, please don't look at it.
My brother is more interested in debating the good things rather than.
My lord, we have always benefited that. My lord, we have always benefited, my lord, by that.
Yes.
And every time we go out of my lord's court, we go out, my lord, enriched in knowledge.
Yes.
And many a time, my lord, I must confess, we are swept off our feet. Of course, my lord, we as lawyers pretend that we are not. But actually, my lord, when we go out and say, his lordship put that question to me, I don't think I was capable of answering it. But of course, my lord, in the court, we do not. So, my lord,
there is no such plea is your contention.
No such plea.
Foundational plea is lacking is your contention.
Yes. And when your lordship looks at that document, my lord, contrary to the perception of my learned friend, I would think, my lord, that it is not an insertion. In fact, I will now show to your lordships with reference to the various documents which I want to point out to your lordships now, my lord, to supplement the submissions that have been made by the first respondent, that this tender has received scrutiny at different levels, and everybody has been of the view that we have to hasten the process because we have lost time already. That you have already lost time. So what does it matter if you lose more time is an argument in nihilism. Some time has already been lost. WAPCOs took so much of time. Therefore, why are you in a hurry today? My lord, that's no answer, my lord. That is an argument in, as I said, an argument in nihilism. Because we have lost so much of time earlier, we do not want to lose more time when it is within our control to prevent wastage of more time. That, my lord, should be the approach. And if that is the approach, my respectful submission is that having regard to the well-established legal position, that in a proceeding under Article 226, your lordships will not go into the merits of the decision. Your lordship will only examine the decision-making process. As to whether that the reasons given in the note of the tender accepting authority, namely the managing director and the board prior to that, is sufficient or not, is not something that falls within the pale of examination in a judicial review proceeding. And my lord, as the learned single judge has pointed out in the order, it is not as if there should be detailed reasons to be borne out in the records as to why a lesser time than 30 days is being given in respect of a particular tender. Relevant considerations have been adverted to. There are no irrelevant considerations that have been adverted to, and plea of mala fides, my lord. Of course, lack of bona fides is pleaded.
No, they are saying that the complexity of the contract and the nature of the work.
Yes.
And its highly technical nature.
Yes.
Was a relevant consideration not adverted.
There, my lord.
In framing that condition.
Yes. There, my lord, my answer to that is simply this, that the appellant has not understood the difference between considerations at the time of formation of contract and those which go to performance of the contract. The requirement of a soil investigation, site investigation, geotechnical examination, topographical survey are all part of the bid or the performance of the contract after the award is made. They are not prior to it. That's the distinction, my lord, which the appellant has lost sight of. In fact, this 8,000 crores, it is for the scope of work which includes this. It is not for award of contract. It is for the performance of the contract. After the award work has been awarded to you, you need to do this, which includes design, engineering, investigation, survey, soil testing, everything. And I showed your lordship the relevant provisions of the tender, which provides for all this. So there is a basic flaw in the understanding of the appellant. As to the considerations which must go to submit the bid, and those which are relatable to performance. If I am right in that submission, my lord, and I shall make good that submission, then, my lord, all this grievance that was made before your lordship, that this is a very complicated project, it involves large civil electromechanical works. All this cannot be done in a 21-day or a 23-day period. It requires a lot more time. All those submissions, my lord, would be unfounded. Because these, which the appellant complains, cannot be done in this 23 days or 21 days as the case may be, are really the scope of the work. You do it afterwards.
No. They are saying that it is not possible to prepare the bid.
Yes, my lord. I'm answering that question. I was about to answer that question. If three others,
They are basically saying that this 21 days period is too insufficient to prepare a bid itself.
I-
And therefore,
my lord,
and that is how the design is created to outs the.
my lord, the answer to that is straight and clear. If three people, if three tenderers have submitted their bid, they're also in the same position.
They too have asked for more time.
No, my lord, they have submitted it within the time.
Initially, they asked.
Initially, they asked. But they got 2 days extension, but they submitted their bid. So if,
How many bidders submitted?
Three.
Three. Including yourself.
Yes, including myself. So admittedly, my lord, three persons have submitted their bid. That's the complete answer to their contention that no, it's not possible. It's not possible by them. If it is not, that's why I said, my lord, if it is oppressive to them, it need not necessarily be oppressive vis-a-vis all others and public interest. And I showed your lordship the correspondence which indicate that it is because their E&M supplier said they cannot enter into any finalized terms and conditions with them. Obviously, my lord, they were not able to work out a commercial term with the E&M supplier. They don't want to tell your lordship that. And even according to them, there are only 3 E&M suppliers: GE, White, and Adrich. Only 3. So all the 3 who have submitted the bid have tied up with one or the other.
So your bid was along with that expert?
One of them. Oh, it must be, my lord. It must be. It must be, even according to the appellant's case.
All of them are one of them.
So be it, my lord. Let me assume it so. Obviously, their commercial terms were a little harsh.
Who is your electro?
Ours, my lord.
Their contract.
G.
All of them are G.
All at G.
So there are only 3 players in that field?
Yes. GE, White, and Adrich.
They have named in the petition.
Then they have that, even according to them.
They are the only 3
They are only 3.
With whom the tie-up can be have.
Yes. And they were all pre-qualified.
And you have the tie-up with one of them.
One of them. And we have done it. And all the 3 have done it. I don't know with whom the other 2 have done, but in any event, the 3 bidders have tied up with one or the other of the E&M manufacturer. I ask myself, why is it that the appellant is not able to do it? The only reasonable answer that we can find out, my lord, is that the commercial terms, they are not able to finalize with the E&M. They have correspondent. I showed you with all the 3 of them. They, my lord, are going to all the 3, and there's correspondence on that.
How much time you had sought for?
Lord, we had sought for how much?
2 days.
I think we are also sought for. We also sought for, sir, how many days?
2 days.
2 days, I think. I mean, I'll find out how many days, I don't know. But we had sought for how many
No,
days?
it cannot be 2 days.
No, we are not. Two days. My lord, I understand, my lord, I might have asked. But considering the fact that only 2 days extension.
60 days, 90 days, I'll want to let him complete.
My lord.
2 days. 2 days finalizing the EPC the MOU between themselves and the G. 1 day actually.
Whatever may be the situation, my lord, I might have asked for the moon. Let me assume that. I might have asked for 6 months. The fact that only 2 days was granted is an admitted position. And the fact that I submitted my bid within the 2 days is also an admitted position. And so did 2 others is an admitted position. So if the 3 can submit their valid bid within the 23 days that had been granted, I ask myself, what is so special about the appellant that they are not able to do it? And I have an answer for that. My lord, obviously, their terms and conditions, they're still negotiating, they're still bargaining. And now they're telling the power corporation, till I work out a satisfactorily agreement with my E&M manufacturer suitable to the terms and conditions which I want, don't proceed. Now today in 90 days, if they're still not able to finish within 90 days, they'll come and say, no, give me more time. 90 days is not enough. Well, where is it going to end? So, my lord, they will dictate to the tender inviting authority as to what should be the date for submission of bid, depending upon their commercial interest. But obviously, it can't be that way.
Yes.
And I also, my lord, had number of questions in the pre-bid. I'm given to understand, my lord, we had the most number of questions in the pre-bid meeting. We also asked many questions. Of course, my lord, everybody has a right to ask those questions at the pre-bid meeting. Well, my lord, the employer has a right to clarify up to a point and say, well, I have nothing more to say. You want to proceed on the basis of what I've already said, do it. Otherwise, don't worry about it. And every one of us has the qualification. We had earlier projects. We have done many other projects. We have submitted our bid, and our bid, my lord, has now found acceptance. If you want to challenge the acceptance of my bid on any other ground, which is non-existence today, my lord, writ court is not the remedy, because there is an appellate provision under the statute, as your lordships are well aware. So therefore, the question would be, can your lordships be invited to go into any other question excepting now a non-existent grievance, namely violation of Rule 17?
Did you take up alternate remedy?
No, at that time, the award had not been done. The question of taking alternate remedy didn't arise.
No, objections were filed.
No. The award was made in the pendency of the writ appeal. The award of work in favor of respondent number 2 was made during the pendency of the writ appeal. Therefore, the question of taking the plea in the writ petition didn't arise. Either because obviously, lordships are aware, my lord, it is only when the award of work that you can file an appeal.
Which section? KTTP.
Yes. 16, my lord, under section 16. Any tenderer aggrieved by an order passed to the tender accepting authority other than the government under section 13 may appeal. So, my lord, your lordship have to go to section 13.
16 is only after award of.
Yes, brother. Acceptance. Yes, exactly. Yes, brother. So, my lord, it's only after acceptance under section 13 that an appeal lies under section 16. In short, my lord, my submission would be, which I shall make good with reference to the list of dates that I have placed for your lordship's consideration, would be that this is a wolf in the garb of a sheep. Please don't entertain it.
Pardon?
It is a wolf in the garb of a sheep.
Garb of?
A sheep.
The garb of sheep. Chadmavesha.
Yes.
In this case.
This is how I would put it, my lord. Don't.
16 applies, my lord, only when a tenderer challenges it. Please have a look at the language. Anyway,
Other than tenderer is.
no, the language itself is tenderer.
Even otherwise also. After the tender, that tender happened, acceptance of tender under 13 happened, pendentility. Therefore, even
That's
otherwise it.
That's the second.
So, my lord, my respectful submission would be that this is not a case where your lordship should interfere at the instance of the appellant, applying, my lord, the law laid down in R.D. Shetty's case. In fact, your lordship will recall, my lord, in R.D. Shetty's case, the court did come to a conclusion on the merits.
No, court
There was a
only
flaw.
laid down in R.D. Shetty, court denied relief to Mr. Shetty because belatedly he approached the court.
Plus, there was a relationship.
Conduct of the
Conduct,
these two.
exactly.
But law has been set.
Exactly. And in R.D. Shetty's case, even though on merits they found fault, they said we will not grant relief.
Yes.
So therefore, my lord, independently of whatever may be the position in this case, at the instance of the appellant who is seeking to promote his private interest, which is not which is, I would say, vitiated by oblique motive, please do not interfere in the order passed by the single judge. And now, my lord, they did get special preference. In fact, you will also put a question to my learned friend when he was arguing, why did you extend it from 21 days to 23 days? That is to everybody. No problem, my lord. Why did you extend it even during the pendency of the writ petition? Well, he got special preference. Nobody has come and questioned that before your lordship. And I have an answer to that question, my lord. That is really to let the cat out of the bag so far as the appellant is concerned. As I say, my lord, take the bull by the horn. If it was bona fide, if you really thought that 30 days, I want something more than 30 days, you therefore cannot exercise a power under 17(2) to reduce 30 days to anything less. All right, take 30 days. Where is your bid? Even that is not there. Therefore, my lord, this is really, if I may say so, to use a fairly loose language, my lord, it is to call the bluff. And this entire contention, my lord, based upon Rule 17 was really red herring. There is no substance in it. It is just brought in order to give some color of law to promote their commercial interest. This is my submission. And therefore, my lord, even though Raunak was in the context of an interim order.
No, color of law is this. The other day, we were asking you whether anything like right to get the bid received. You said there is no such right.
Yes.
For any party, intending bidder. But somebody invites an offer and person is an offerer. Then has he got the right to make his offer or not? And in that process to be treated fairly. That is the color of law they are developing.
Yes. But the question.
New thing, but that is all said and done, private interest, commercial interest. This is challenge to condition. But right to be treated fairly while going opportunity to make an offer.
Yes.
That too by a state or condition.
Yes. My lord, answer to your.
That is how they are trying to develop.
Yes, my lord. Answer to that question is partially yes and partially no. My lord, if on the face of it, without getting into the merits of the decision making, your lordships can come to the conclusion that it is unfair or arbitrary. Yes, your lordships can. But if the decision as to whether the offerer was prevented from making the offer is really within the realm of the decision itself, the reasonableness of the decision itself, can the court interfere? The answer is no. That's the distinction I make. And in this case, the question as to whether the offerer was deprived of a reasonable opportunity to make the offer is intrinsically connected with the correctness or otherwise of the reasons given for limiting the time period. That your lordships cannot go into. Unless, my lord, it comes within the 3 exceptions laid down in the Tata seller case.
No, you were the first contention. We are just contemplating. You said if 3 persons could be in the fray.
Yes.
He also could have been, is your version.
Yes.
He had an opportunity.
Yes.
Suppose when there is a running competition 4 persons have to run only after whistle is blown. But before whistle is blown, 3 will run. And the 4th one is waiting. They can also say, no, we had opportunity, equal opportunity to run even before the whistle was blown.
Yes.
What's your answer?
Well, our answer is that in this case, all the 3 began to run after the whistle was blown. And in fact, the appellant started to run before the whistle was blown. I showed your lordship the document. And exactly, my lord, the appellant began to run even before the whistle was blown.
Before?
Whistle was
Even
blown.
before the whistle was blown.
You're right.
Appellant began to run.
You visited the site.
Yes.
You inquired.
Exactly.
There is a document of your visit.
Yes.
And how come that, but it started even before the.
But that is because I tell you, that what was not told to your lordship
how
was,
can that, he
I tell
started
you,
even before date
I
of
tell you,
death?
there is what is called as a pre-tender notification was issued.
It was on.
I give you now, your lordship may take my list of dates. That is was not, has not been told to your lordships, I showed you.
January.
Probably in January.
January it was.
Yes. That the pre-tender notification was issued. They asked for clarifications. They took the inputs, and then, my lord, this entire tender was placed before a pre-tender scrutiny committee, which is headed by a retired judge of this honorable court, and 2 members. One is a finance member, the other is a technical member. They have all scrutinized it. An appellant wrote to them also. Now, my lord, if lordship.
So even otherwise, he had sufficient time, is your
Yes.
version?
Yes. Yes.
From January.
Yes. Exactly. He started to run before the whistle was blown. In fact, we started to run only after the whistle. I will take him to this and then we'll read.
Rule 17 is mandatory.
My lord,
Any judgments are there?
my lord,
No, any judgments are there.
No,
It is not mandatory because it contemplates the giving of reason and reduction of.
my lord, I must tell your lordship, my lord, that
Two single judges have very frugally treated the subject.
and the only law, my lord, that is available is to say what is the extent of reasons to be given for the purpose of Rule 17(2). Should it be elaborate?
No,
or
that need not.
that is-
That's what Justice Arvind Kumar.
Yes,
perhaps
yes,
is,
exactly,
framed.
exactly. And that has been relied upon by
No,
the.
my lord's question is
My lord, I'm sorry.
whether any court treated the text of Rule 17, Section 17,
Rule 17.
the Rule 17 being mandatory. There are 2 single judges judgments. With due respect, I feel, I should say, I feel they could have been very elaborately dealt with. There are
Lord,
2
I
judgments.
must confess, my lord, I am not been able to locate any judgment on the mandatory nature of Rule 17(2). But in any event, my lord, today the question, even according to my learned friend's submission, the violation or otherwise of Rule 17(2) pales into insignificance.
Because time was given. Extension. He was
Yes,
given an
extension,
offer.
exactly, because of the fact that he was given 32 days as a special treatment. A person, appellant, in the course of learned single judge.
In course of.
Yes, my lord, on 4th of March, they were given extension of time. They were told, my submission was made before this learned single judge saying, even today, please give me a bid, I will accept it. Doesn't matter, don't worry about the time. What more can I? In fact, somebody else could have had a grievance to say, don't allow them. Yes, my lord, in the interest of all, my lord, all those general propositions, my lord, that there should be ample opportunity for competition. Competition is good for in public interest, my lord, all that I don't think I'm going to dispute, my lord. The question is, in the facts and circumstances of the present case, is there injury to any of those accepted principles of public interest? My answer is no. So therefore, my lord, without going into the larger question on which there can be no debate, my lord, after all, the entire concept of tendering is only that. Invite as many people as possible, take the best which is in public interest and then award the contract. It's a public largesse. My lord, there's no question about all that. My lord, I don't think we need, I would want to detain your lordships on those propositions at all. So let us therefore, my lord, my respectful request to your lordship is to look at the facts of this case. My lord, would your lordship kindly take my list of dates? My lord, I'll quickly take your lordship through that and then point out what I think is relevant and make my submissions with respect to that. Now that I have given your lordships a broad picture of what I want to say. Anna? Really? Just for completeness, my lord, it is 1965 Supreme Court 1008. Though it arises in the context of a civil dispute, if your lordship will kindly see, my lord, paragraph number 8.
For the proposition?
For the proposition, my lord, that a plea of fraud cannot be raised by way of an amendment. Yeah, we'll show that. Para 8, my lord. If your lordships will permit me to read that.
It was urged.
Yes, ma'am. It was urged. It was urged before us by Mr. Settlewalt that an entirely new case has been made out in amendment and that the plaintiff did so at the suggestion of the court. In support of his contention, he also referred to the objection of Mr. Gupte before the High Court to the effect that plaintiffs had not made an application for the amendment of the plaint. He further, relying upon a reference to the judgment, said that the amendment proposed by the plaintiff was not found by the court to be adequate and that it was at the instance of the court that the plaintiff proposed the amendment which now actually finds place as para 8A of the plaint. There appears to be a good foundation for what Mr. Settlewalt says, but merely because an amendment was sought by the plaintiff at the suggestion of the court, it would not be proper for us to disallow it unless there are grounds for holding that it was forced upon an unwilling party. That is, however, not the suggestion. For the court wanting to do justice may invite attention of the parties to defects in pleading so that they could be remedied in the real issue between the parties tried. There is, however, another ground and a stronger one which impels us to hold that the amendment should never have been allowed.
Mr. Raghavan, due respect, please do not mistake me. Fraud in private law, qua fraud in public law, different. If it is a fraud in private law, then the proposition applies. That's how Kerr on fraud treats the matter. Mitra on fraud treats the matter. This was a case because
it is a civil dispute. It is a civil dispute. Of course.
It's not only civil. Even in civil dispute, there can be public fraud.
Yes.
Fraud is a ground in private law for avoiding the contract. Coffum, doctrine of Coffum, which English courts used to say. Coercion, fraud, mistake, undue influence. This is a case which relates to fraud in private law. Fraud in public law was treated by Lord Coke. We have followed it in Meghamala, in P. Chengalavarayan Naidu, and in Meghamala series. Therefore, a decision which is structured on a private law principle cannot be invoked where fraud in public law is involved. There are such judgments.
But then I have one respectful submission to make in answer to what has fallen from your lordships. Fraud in public law, I bow down, is different from fraud.
Under contract law, I have seen fraud is a ground for voiding a contract.
Yes, you're also right.
Whereas in public law, fraud is a vitiating factor. It vitiates celestial actions, temporal actions, religious actions, spiritual actions. In English law, legislative action also. That's how law has been developed. Kerr says this. Kerr on fraud says this.
My lord, I can have no... That, my lord, is what fell from the Honorable Chief Justice when he said, cannot the court look at it? Yes, if fraud in public law, the court can look at it. But when it is to come from a party, the court will not look at it. If your lordships are looking at it, but not in judicial review proceeding, possibly your lordships can look at it even without a pleading. I mean, I'm not on that question.
For example, res judicata.
Yes.
Res judicata is too big a concept. Too big a concept. But res judicata as enacted in section 11 of CPC is a restrictive res judicata, even with amendment of constructive res judicata.
Yes.
There, a suit cannot be resisted on the ground of res judicata, dehors section 11. That is the law. Similarly,
but my lord, section 11 is not exhaustive, is what Supreme Court has also said.
Therefore,
Yeah.
I'm telling you, after amendment, that
Yes.
is after 76 amendment.
Yes.
Before that, the 5-judge bench of the apex court said, a suit cannot be resisted on the ground of res judicata outside section 11. Therefore, law commission suggested go for a wider constructive res judicata.
Yes. Yes. My
Point is not that. Point is, there is a see difference, even a blind can see, between fraud in private law and fraud in public law. They are building up their case on the ground of fraud in public law, although they did not much articulate it in so many words. But that's how we have understood.
Now the question, Manoj, is can they articulate it? Is the question.
That's all.
That is the point I'm placing. My lord, I straight away conceded to the position, my lord, that the Honorable Chief Justice put to me. Forget about the party. Can we not look at it? Your lordships can look at it. No difficulty, my lord. I'm not saying. In fraud in public law, the court can look at it. I mean, I cannot, my lord, after all judicial review is meant only for that. But is the party stopped from saying it, whether it is public law or private law? I would say the party is stopped from saying it, even if it is public law. My lord, kindly now see, my lord, just a few more sentences in this. My lord, please see, my lord, a few more lines in this. For the court wanting to do justice may invite the attention of the parties to defects in pleadings so that they could be remedied and real issue between the parties tried. There is, however, another ground and a stronger one which impulses to hold that the amendment should never have been allowed. That ground is that the plaintiffs are now making out a case of fraud for which there is not the slightest basis in the plaint as it originally stood. The mere use of the word mala fide in the plaint cannot afford any basis for permitting an amendment. The context in which the word mala fide is used in the plaint clearly shows that what the plaintiffs meant was that the order of the corporation, not it was a public law, was, my lord, even though it is termed as a suit and it is actually, my lord, a order passed by a public authority. Your lordship may see the facts, my lord. Yeah, and they invoke, my lord, 19(1) F and G. Meant was that the order of the corporation, having been made in exercise of arbitrary powers and having the result of adversely affecting the plaintiff's right under Article 19(1) F and G of, obviously, my lord, public law of the Constitution, amounted to abuse of process of court and was thus mala fide. The court was alive to the requirement of law, etc., etc. Therefore, my lord, even this was a case, not simply a dispute between a private dispute arising out of a contract between A and B. This had the shackles of public law also. In any event, my lord, independent of that fine distinction that your lordships are pointing out between public law and private law, question, my lord, is can the appellant be heard in the absence of a pleading on the basis of an amendment that is sought in the writ appeal? And to what? Not to the writ petition, to the grounds. My lord, we have all come across, my lord, where in appeal we seek amendment of the plaint. But that's not done here. Yes, and in fact, my lord, there is a finding recorded by the learned single judge, which I want your lordship to kindly see, where the learned single judge holds, my lord, that there is no insertion. No, give me the finding of the learned single judge. My lord, kindly see page 14, my lord, of the order of the learned single judge. Give me that one sentence which you showed me just now. My lord, kindly see, my lord, internal page 14. of the order of the learned single judge. Order.
Amendment.
Yes, and it's part of the amendment application.
In that order.
Yes, my lord, yes. My lord, it is at page 58. Page 58. Oh, I see, okay. Internal page 14, I'm sorry, there's some confusion about the page number 868. 868, kindly see the
Para
reasoning.
11.
My lord, just above para 11.
The
On
reason
top.
found
The
in-
reason found in the note sheet is as afore extracted. Entry 41 is the direction. This is what, my lord, is alleged to be a insertion. Yes, my lord. At page 13, my lord, commencing from page 12, the learned single judge, my lord, extracts the whole of the note. The relevant entries in the note sheet are as follows: 34, 36, 40, 41. And then, my lord, discussed with FD and TD, and then the note, my lord, which gives reasons. Then, my lord, paragraph, page 14. The reason found, my lord, got it. Your Lordship, the reason found in the note sheet is as afore extracted. Entry 41 is the direction by the managing director to discuss the issue with the director, technical and finance. The continuity is found in the discussion, which is as afore quoted. The discussion also notices the resolution of the board on 1/2/2024 for calling a short-term tender for 21 days. Therefore, the director, technical and finance approved calling for tenders as found in entry 34. Resolution of the board is also appended to the statement of objections.
Where issue of insertion is treated?
Issue of insertion was not taken.
Not taken.
There was no such pleading. Rightly, my lord, the learned single judge did not even examine it. And therefore, my lord, I am now saying, can it be urged a serious allegation like that by way of an amendment to the writ appeal grounds? They could have raised it before the learned single judge. It's nothing new. I mean, if my learned friend, I'll take my learned friend's word for as true, my lord, that he argued it. If it was argued, why was not the petition amended? Saying, I came to know about it when the statement of objections was filed by the Karnataka Power Corporation. I have now examined the records. Clearly, to the naked eye, it is insertion. Very well, but right or wrong, they could have urged it. They didn't. Now, my lord, I would request your lordship to kindly see the list of dates, my lord, so I'll take your lordships to that and point out, my lord, all the relevant correspondence with the appellant has had with the E&M manufacturers and how it all happened. My lord, please be kind enough to, I'll quickly go through this, my lord, and then. To mitigate the energy fluctuations in the grid, my lord, my list of dates, synopsis, which I placed for your lordship's consideration just. To mitigate the energy fluctuations in the grid due to high infiltration of solar and wind energy, KPCL has proposed to implement PSP within the existing hydropower complex and hence awarded the work of DPR to Messrs. WAPCOs Limited, Government of India undertaking under the Ministry of Jal Shakti. My lord, that report, my lord, is there at page 504. WAPCOs conducted a detailed study and submitted its draft DPR. Annexure R6 is a technical specification, scope and description of the civil and hydromechanical works. Then 9/10/2023, WAPCOs was entrusted to prepare the tender documents and the same was submitted to KPCL. All these are technical bodies, my lord. WAPCO is a technical body. They have gone into everything. Now, my lord, please. Now, please see 9/1/2024. Draft 90 by state tender scrutiny headed by a retired judge, technical member and financial member. Please be kind enough to see this, my lord, on 9/1/2024. Lord, your lordship will find it.
Volume 2.
Yes, my lord. Page 341. 341. Yeah. Lord, your lordship may kindly see. I want your lordship to kindly see, my lord, the scope of the work on the first page at page 341.
I don't know where they get this, my lord, High Court judge, this, that. And
We'll
all
show
that.
it, we'll try.
Not even argued by the KPCL.
It's on the record. It's on the record. It's on the record. It's in there in my list of dates, sir.
Yeah, your list of dates is there, correct?
With reference to the document also. I show it. To you. Just give me a minute.
So this WEPCO report was part of tender.
Madam?
This report by WEPCO
Yes.
was part of tender.
Yes. No, it was not part of the tender. It was submitted given to them subsequently. No, it was not.
But it was an exercise prior to tender.
Yes. It was an exercise which was done, my lord, from August 2021 and 2023. It was well before, my lord. It was not part of the tender. In fact, it was given to them on the 17th of February.
They were aware of it.
On the 17th of February.
17?
February.
21st, my lord, is the
Yes. My lord, why I showed you exactly what I'm going to say. Show to your office. That WAPCO's report was given to them as additional information. You want to use it, use it. You don't want to use it, don't use it.
17 February, date of tender.
No, the date of tender was earlier, but not, it was given on 17th February.
2nd February.
2nd February, my lord, is the date of the NIT. 17th February it was given. And then just because an additional document was given to them.
One of the defense raised by the other side, probably by the corporation, is that the tender work and the scope of tender work was available to be seen from this WEPCO's report. If that is so, then therefore in the, probably if we are, I may not be that precise, but that is the line of the defense, one of the line of.
Is there, I point.
No. My lord, the scope.
If that is so, then therefore we are asking whether this report was available at the time.
No, my lord, the scope of work of WAPCO's was independent of any tender. Now, my lord, the question is, what is the scope of work of the tender?
No, that was of the year 2021.
21. And now please see, my lord, what is the scope of work? My lord, they whatever WAPCO's might have done or might, suppose, my lord, I ask myself a question. Suppose I had not given them WAPCO's report. My lord, it means KPCL had not given the WAPCO's report at all. Could any tender have said, no, give me the WAPCO's report which has been prepared, a DPR, and without that I'm not going to tender. I say, I'm not giving it to you. Do what you want. This was just because this was given to them as an additional piece of information.
Everyone. As a para 17 of the objections of KPCL itself, KPCL says it is needed. I'll point out that. Their own objections.
My lord, suppose, my lord, it had not been given. Let us take the extreme case where WAPCO's report was there. There was a bid query. It was not given. We said, we are not giving it to you. This is for our internal purpose. Do what you want. Because the scope of your work includes this. Maybe WAPCO's report is right. Maybe it is wrong. Tomorrow, don't come and tell me that, oh, I bid it on the basis of the WAPCO's report and the WAPCO's report does not give correct information. Therefore, I was misled. I do not want to get into any of those situations. You do that yourself and submit a bid.
So
therefore, my lord,
yes.
What is important is to see the scope of the bid. That is most important. Kindly see the pre-tender now. Because your lordship possibly have not been told till now that before the issue of the NIT, there was a pre-tender.
9 January.
Yes, my lord. Yes, correct, my lord. 9 January. Your lordships are right. 9 January 2024, which is available, my lord, at page 341 of volume 2. Now, my lord, please see the work. That is very important. This is not a work for simply a EPC contractor. My lord, they were not supposed to be EPC contractors. That is the difference, my lord, that I want your lordship to kindly see. Kindly see now the scope of work. Design, engineering, manufacturing, testing at commercial works before dispatch, supply, transportation, storage at site, intrastate transportation, insurance, transit, storage, erection, testing and commissioning, erection, testing and commissioning of 8 numbers of vertical Francis reversible pump turbines and synchronous motors generator sets, each of 250 megawatts capacity, along with all associated auxiliary ancillary equipment, etc., for this purpose, for the Sharavati pump SP project. So even the design was with them. And I asked myself, how do you do a design without site investigation, soil investigation, topographical study? My lord, that question which I asked myself is answered in the tender. I showed your lordship that, my lord. Now, my lord, this draft tender was, in fact, my lord, they also wrote letters to the pre-tender scrutiny committee. And then, my lord, the pre-tender scrutiny committee approved this, it was issued. And then, my lord, kindly see, my lord, even as of 17/1/2024, this was issued, my lord, on 9/1/2024. Even as of 17/1/2024, the appellant, my lord, writes to KPCL saying, please extend time. Kindly turn to page 352. 352, your lordship gets it in volume 2.
Annexure E.
Yes, Annexure E. At the very outset, we would like to congratulate KPCL, etc., my lord. We are very much eager and excited to partner with you to transform this project from concept to reality. We would like to inform you that due to some system-related issues at our end, we could not give our suggestion on the draft tender document on the e-procurement portal. However, we are submitting the same along with the email to you. We hope that our suggestion will be given due cognizance and will be incorporated in the final bid. Now, please be kind enough to turn to page 353. Number 2. Kindly see the last column, observation and L&T suggestion. At page 353, my lord, serial number 2, the last column. Now, my lord, they set out the timeline, date and publishing of ABN and BBM in so-and-so 16/1. Last date and time for submission of bid document 15/2/2024. That is because of the pre-bid document. 15/2 was there. Based on the above timelines as mentioned in the draft document, only 30 days time has been allocated for preparation and submission of comprehensive techno-commercial bid for a project of such magnitude and complexity, including E&M work. Based on our prior experience, we feel that the minimum time of 90 days may please be provided. Lord, what is important, I want to point out to your lordship, is based on the timelines as mentioned in the draft document, only 30 days has been allocated for a project of such magnitude and complexity, including EM and HM works. So ultimately, my lord, it all boils down only to that. Yes. Now, my lord, please be kind enough to turn to page 359 when your lordships are at this. As your lordships indicated before the whistle was blown, they started running. Kindly turn to page 359.
It's in volume 3.
Yes, my lord. Same volume, my lord, that your lordships have.
Volume 3.
Volume 3. Volume 3. Oh, it's a different volume. I'm sorry. Thank you. Volume 3. This is volume 2. That's volume 3.
Page.
As your lordship will kindly see, my lord, 9/1/2024 is the date on which the draft NIT was published. They came to know about it. Now, my lord, on the same day, on 9, my lord, on
5/2.
on 5/2. Yes, kindly see, my lord, on the letter dated 5/2. In that they say from 9/1 itself we have been approaching. Kindly turn to page 360, paragraph 5, Roman 1. Yeah. May I read para 5, my lord, so that your lordship gets the context of the statement?
As you are aware.
As you are, yes. As you are aware, in a tender process such as this, public interest requires a wider participation of bidders to ensure healthy competition. Conditions in the NIT which would result in restricting and or disabling participation of otherwise capable and competent bidders would be unreasonable and contrary to public interest. We would humbly like your good self to revisit, review and modify the below mentioned key conditions of NIT. Clause 17. A timeline of 18 days for preparation and submission of techno-commercial bid has been proposed. However, it is crucial to acknowledge the extensive nature of a project of this magnitude, particularly when undertaken on an EPC turnkey basis. Preparation of a techno-commercial bid would at the very least entail comprehensive efforts and steps towards 1. Site survey, and kindly see, Manoj, these are all very important. This is the scope of work, and I showed your lordships. Site survey and investigation, which for a non-local bidder to arrange for and complete can be estimated to take at least 15 days. Preparing a preliminary basic design, which can be estimated to take at least 45 days. Coordination with E&M and HM contractors and soliciting their feedback for the design of civil components, which can be estimated to take at least 90 days. That is why there is 90 days in the writ petition. Additionally, detailed discussions with foreign lenders regarding numerous brought out items will be necessary, which can be estimated to take at least 30 days. We would also like to bring to your attention, this is very important, my lord. We would also like to bring to your attention that based on the draft tender document as issued on 9/1/2024, we had multiple rounds of discussion with major E&M manufacturers. So, my lord, even as of 9/1, they have started scouting. Good for them, my lord. I'm not saying they should not.
Scouting multiple rounds of discussion.
And they have had multiple rounds of discussions. And they have indicated a minimum of 3 to 4 months, which will be required by them to prepare the proposal for a project of this magnitude. The proposal is not simply what happens between them and KPCL. Proposal, my lord, is inter se between L&T and the E&M. And they have been doing it from 9/1/2024. That is why, my lord, at serial number 5 of the list of dates, I have put 9/1/2024 as the date on. Admittedly, L&T started reaching out to E&M partners and started preparing the work to submit its bid, borne out from the letter of L&T dated 5/2/2024 to KPCL. This is the one what I point out, your lord. Then, my lord, kindly turn to serial number 7. I have already pointed out, your lordship, not serial number 6. Now, please see serial number 7. That's important. My lord, please be kind enough to turn to page 476. Well, this is the statement of objections that has been filed by KPCL before the learned single judge. Para number 2.
476.
476. 476. Lord,
Begins at 475.
My lord, it begins at page 475. Your lordships are right, my lord. It begins at 475. I am inviting your lordship's kind consideration to page 476, my lord. Paragraph number 2.
This is by which respondent?
No, this is the statement of objections filed by KPCL before the learned single judge.
But will be able to complete the hearing in this session or not?
No, I think I will, man. I will. I will quickly go through this. Complete. I will. I understand. No, I will not.
We are not curtailing you, but
no, my lord, I understand, my lord. I followed what is in your lordship's mind, my lord. I will. My lord, para 2, my lord. Petitioner contends that there is not sufficient time, as only 21 days time has been given for the purpose of submission of bid, which is grossly insufficient. The submission in this regard is misplaced for the reason that the draft tender notification was issued on 9/1/2024 by the State Pre-Tender Scrutiny Committee, and the petitioner representative, one Mr. Srinivas, has been visiting the offices of the answering respondent from 18/1/2024 and has been collecting information. The said person met the engineering team and had detailed discussions on 23/1 and 24/1 in relation to geotechnical investigation and requested for permission of site visit. And in fact, my lord, permission was given, and the KPCL, my lord, has produced the visitor's pass that was given to them.
Please look at para 16 and 17 of this very document. I think, that makes it clear. Page 483.
My lord, I would have really read it, my lord, but for the time constraint, my lord, that can eat into his time, my lord. So, my lord, kindly see, my lord, at page 527 now. What did the state pre-tender scrutiny committee do? But please be kind enough to turn to page 527. This is, my lord, the extract of the board of directors meeting of the power corporation. My lord, if I may trouble your lordship to kindly see Roman 1. This is dated, my lord, 1/2/2024. There is a reference, my lord, to what the SPTSC has done. If your lordship will kindly see first, my lord, Roman 1. The 293rd board held on 20th of October 2023 noted the progress of work with respect to Sharavati pump storage scheme and its need to the state grid in order to mitigate the energy fluctuations in the grid due to high infiltration of solar and wind energy in the state of Karnataka and effective way of reusing surplus power, and the board authorized managing director for the following. Now kindly see. My lord, all this has to be seen, my lord, and in a holistic manner it is submission I am making. And managing director was asked to look at the following, namely to expedite the work at the earliest. Then, my lord, Roman 2. The board noted, observed the progress and present status of the project with respect to CEA, environmental clearance, online application submitted to Parvesh portal for obtaining forest clearance and wildlife clearance as stated in serial number 2 of the agenda note. Further, the board was apprised on the status of the tender as follows. The draft tender document for implementation of Sharavati PSP and EPC mode on EPC mode has been submitted to the State Pre-Tender Scrutiny Committee on 5/1, and presentation regarding the tender document has been made to the committee on 18/1, and the SPTSC has submitted advisory on the same on 24/1. Therefore, my lord, this has gone through all that I was at pains to point out, not what the State Pre-Tender Advisory Committee has recommended. It's a mere recommendation. But all that I was at pains to point out, your lordships, because especially in the context of what fell from your lordships on the previous occasion, did somebody technical look at this? The answer is yes, at multiple levels. State Pre-Tender Advisory Committee, my lord, which of course, I mean, it's of public knowledge that it is now headed by a retired High Court judge.
Lord, there is neither pleading.
My lord, this is
document. For the first time, my learned friend is saying all this, not even KPCL. I'm surprised.
But this document was part of the statement of objections.
Yes, this is part of the statement of objections. This is part of it.
Court judge, all that, I don't know. It's all to prejudice the mind of the court.
The board, draft tender document for the implementation of Sharavati PSP and EPC mode has been submitted to the State Pre-Tender Scrutiny Committee on 5/1/2024, and presentations regarding the tender document has been made to the committee on 18/1/2024, and SPTSC has furnished their advisory on the same on 24/1/2024, and then, my lord, they refer to WAPCO's report. Now, my lord, after this, all this, and then, my lord, the tender document was issued. Now, my lord, there's one very important development that has taken place again now. Please be kind enough to turn, my lord, to page 698.
Volume 4.
Yes, my lord, volume 4. Respectfully, my lord. My lord, this is an email dated 25/1/2024, addressed, my lord, by the appellant This is an email dated 25/1/2024. Your lordship may note, my lord, this is before the tender was published, because tender was published only on 2/2/2024. Now your lordship may saw, my lord, that even at the time when the draft tender was issued, they already contacted one E&M. Now this is another E&M. This is E&M, my lord, White. Tried to call you, etc. Be aware that KPCL Karnataka is likely to issue the official tender for 2000 megawatt Sharavati comprehensive, etc. project. This is the appellant's email to White, even before the tender was issued. First attempt was before the pre-tender. After the pre-tender, this was before the tender.
Next page.
And now, my lord, please be kind enough to turn to page 699. I understand from KPCL that White was involved extensively on this project. In the pre-tender phase with them, we would like to explore collaboration with White as a consortium partner as per the provisions of the tender. Can we talk about this and accordingly move forward based on your interest feedback? No issue, my lord, what time, nothing. They were wanting to negotiate with White. And on this, there was no response from White. And then, my lord, between 23/1/2024 and 24/1/2024, the representative, my lord, I'm at serial number 10 of my list of dates, my lord, visit the site for collecting information. And then, my lord, your lordship may kindly see page 476. My lord, it's not an issue, my lord, because the visitor's pass has also been produced. That's not an issue, my lord. I'm not going to tell your lordships. Then, my lord, between 1/2 and 2/2, respondent number 1 arranged for site visit, and they visited the site, surveyed the site. Now, my lord, there has been some pre-tender deliberation of the Karnataka Power Corporation, which is on record. So, my lord, that I think your lordships have already seen it, my lord. In order to keep within the, in order to, my lord, I know, my lord, the very polite warning that my lord, the Chief Justice.
No, we are withdrawing.
My lord, my lord, it was very polite, my lord. I understood.
After everyone argument will remind us that.
My lord?
After every sentence of argument, we will say that we have said.
No. I want.
This is all in. So which page that?
My lord, kindly turn to page 527 onwards of volume 3. My lord, we have already shown it, my lord. That is the minutes of the board meeting which I showed to your lordships of the Karnataka Power Corporation. Expedite the work at the earliest as the state is facing acute power shortage.
527.
My lord, 527. I take it.
Yes, that we.
Yeah, your lordship has seen it. Then, my lord, after 527, your lordship may kindly turn to page 531. .03. Under these circumstances, the board resolved that approval be and hereby accorded for the following. Roman 3, my lord, to publish short-term tender. So board said, consider 21 days in Karnataka Public Procurement Portal. And then, my lord, page 520.
In other words, what you say is,
yes,
it is not that when the tender came to be issued, prescribing particular period is short, you have to look into that. In the background of what all has happened is your version.
That's yes.
If that is taken, the argument of shortness would fall to the ground appears to be.
And the argument that this is a subsequent insertion also is baseless. It isn't.
Irrespective of that note.
Exactly. With respect to the note, yes. If everything is taken together, my lord, all the authorities have applied their mind. They're all thinking alike that we have to expedite the entire process. And if each officer takes certain step, especially the officer authorized under law.
That note is subsequent to this point of that. Yes. 1/1, this is 21 days.
Of course. Yes, it is. It is. There's no doubt. There is no doubt that the note of the managing director where he says, I'm going to make it 21 days is of course subsequent. It has to be taken in the context of the entire. This is all that I'm saying. And then, my lord, the publication was made on 2/2. Now, my lord, what is important for your lordship kindly see is please see page 115 because this is important in the context of my submission that the grievance that is being made by the appellant before your lordship goes to performance, not to formation. And according to me, my lord, there is a world of difference between formation of contract and performance under the contract.
Law at the entry level.
Law at the entry level, what happens after the entry level, after you've been awarded the contract. Now, all that is being told to your lordship is, how can I perform my obligations under the contract? That's a different issue. Were you required to perform the contract before submitting your tender? No. Please see, my lord, a few clauses of this tender which has not been pointed out to your lordship, which I want to point out to your lordships. Please be kind enough to turn to page 115. At volume 1. What? Yeah, we'll come to that. This is the pleading of petitioner. Yeah. When I'm making this point, we'll. Yeah, sure. Correct. Yeah. My lord, please be kind enough to turn to page 115. My lord, please see the
115 is in volume 2.
My lord, 115 is volume 1.
Volume 2.
Volume 1.
No, volume 2.
I'm sorry, my lord. Sir, my lord, I think I request your lordships, my lord, with apologies, to just correct it as volume 2.
No issue. No issue.
My lord, would your lordships be kind enough to turn to a few clauses of this? Please be kind enough to turn, my lord, to page.
First page of, second page.
My lord, first page, my lord, your lordships have seen. Now, where do you get this investigation?
Second page of second volume, na?
Huh? 1?
115.
My lord. Yes, my lord. Where is the page numbers here in this note? Where is the page number note? 187. My lord, kindly turn to page 187, my lord. That's what I'm saying. Lord, please see page 187. Kindly see the definition of the term investigation. This is part of the work which is required to be done under the tender. Investigation means in the EPC contract, after site visit and inspection, the contractor has to conduct the investigation for submission of drawings and designs, not for bid. For employer's approval, so also bill of quantities to be submitted for approval depending upon the nature of work and separately for civil H&M and EM works. Yes. And if your lordships will pardon me for taking your lordships back to page 136 and kindly see the scope of work.
What is EPC? EPC? What is EPC?
EPC, engineering procurement contract. Engineering, procurement and construction contract. I'm sorry. EPC contract is engineering, procurement and construction contract. Everything was included in this.
No, why you are drawing our attention to the
I am
definition?
drawing your attention to this for this reason, my lord. I want to show to your lordships that this investigation, etc., in respect of it, so much of complaint is being made to your lordship saying it requires so much of time, it's so complex.
It will come afterwards.
Afterwards. That is the point. It is to performance, not to formation. That's the submission I'm making.
This is the this is why they say sites are
Yes. And this, my lord, this submission, I will show to your lordships after I've shown all the other clauses, is to show how palpably wrong the stand they have taken in the writ petition. They misunderstand the scope of their work pre-bid, and then make a grievance that the time available is not sufficient.
No, it's their only contention is to make a rational decision as to participation in the tender process. We have to have the rough estimation of the amount.
Please go visit whatever you want to do. Go do whatever you want.
From that angle, they are
Yes,
making
go do
argument.
whatever you want to do. That does not flow from the terms of the tender. Yes, that's what your lordship say. And after I shown to your lordship the relevant clauses, my lord, I will show to your lordship the paragraph in the writ petition which palpably shows that they have misunderstood the scope of work pre-bid. Pre-bid, all that is the grievance made is not necessary. Suppose, my lord, after the award of work, suppose a particular work cannot be done within the time stipulated under the contract because of A, B, C, D reason. Those are all independent matters to be sorted out in the course of performance of the obligations of the parties. It is not for the purpose of submitting a bid, which is an offer. That is the main contention that I am placing for your lordship's consideration. If I am right in that submission, all the grievance that has been made will be irrelevant. And now, my lord, please be kind enough to turn to 1.6 at page 136 of the same document. Yeah. No.
Dictionary clause.
But yes, but kindly give me a minute. Kindly give me page 136. Kindly see. 136. Lord, please see the scope of bid clause, my lord, at 1.6. Karnataka Power Corporation, hereinafter referred to as the purchaser, invites bids from eligible bidders as follows. The scope of work, that is important, my lord. The scope of work shall include all the items and services specified under the accompanying technical specifications and all accessories, even though not specifically mentioned in the specification schedules, etc. Because it was, my lord, a turnkey project. It is not a line item project where there is a rate for each item. No, it was not that. He said, we want this particular project. These are our specifications. Tell us how you can do it. He is
Whether we specify or not, it's a turnkey basis.
Turnkey
contract.
basis. Because it was obviously not a very complicated project. Nobody is disputing that. All accessories, even though not specifically mentioned in the specification schedules, etc., but which are essential for the satisfactory performance of the plant. That is design, engineering, manufacturing, testing at manufacturer's work, before dispatch, supply, transportation, storage at site, intra-site transportation, insurance, erection, testing, commissioning of 8 numbers of so and so, so and so. Now kindly see the next one, Mala. The scope will include the following. Detailed design of the entire plant. Mala, this plant is mainly comprised of tunnels because it's all underground. You have to do everything. That is the detailed design of the entire plant. Is your responsibility, is what KPCL telling every one of us. Not only to the appellant, to the world at large. Providing engineering drawings, data, bill of materials, QAP of all the equipment, etc., complete manufacture, then everything, my lord. I'm not going to detain you lots of reading all this. The scope of work is so broad. Where is that page? 617. Kindly now turn to page 617 of the same volume, my lord. Volume 3. Thank you. But please see 617. Now, what should your price include?
600, 300.
617, my lord.
Volume 3.
Volume 3. What should your price include? is the question, my lord, that I ask myself, and answer is found at page 1.16.1 at page 617. The rate shall be inclusive of all required surveys, geological and geotechnical investigations, designs, supply, and execution of all the components of the project, including consultancy services for geologists from the GSI, CSMRS, and other consultancy services required under this contract, and as requested by KPCL whenever required for satisfactory completion of designs and engineering by the contractor and for obtaining approvals by KPCL. My lord, in your bid itself must include the cost of all this. Why are you doing it before? Well, if you want to do it, nobody prevents you. But that cannot be a ground for grievance. Yeah. No, but it's not there, no. My lord, there is one other document, a part of the bid document, which is, I'm given to understand, my lord, is not part of. This is court. And I will copy first. Our copy. Give him a copy, no? Give it. My lord, I'm told the one page of a bid document has not been given to your lordships. Can I have their permission to?
It was part of the record in the court, before the learned single judge.
His question is, was it part of the record of the learned single judge? No, my lord, not. We were not there, my lord. When I tendered, our one copy.
Which he himself has produced. Minus one
Our
page.
selectively, our Allah hakilla. Yep. 1.8.1 yeah. This is
After the document.
no, it's not. It is not. But this is part of the tender document. Well, kindly see 1.8.1. Contractor shall make.
That is general description of soil.
Respectfully, my lord.
So all these you are pointing out to show that is part of performance.
Exactly. Not. That's. And in fact, my lord, it says, and has to carry out detailed geotechnical after the award of contract. Specifically. My lord, I think the other tenderers, my lord, understood the tender conditions correctly. Appellant did not. And now my lord wants to take benefit of his wrong understanding. One more, anything else? That's all, no? Other thing. Okay, now give me page. My lord, please be kind enough now, my lord, to see the wrong understanding of the appellant is clear from their assertion in para 15 of the writ petition, which your lordships will find at page 92.
In first volume.
Yes, ma'am. Please see para 15, my lord, if your lordships are kind enough. May I place it? In the circumstances The petitioner addressed a communication dated 5/2/2024 and made a representation to the respondent, reiterating its objections to the said condition and further emphasizing that the said condition being a nature that would restrict disabled participation of otherwise capable and competent bidders was unreasonable and contrary to public interest. The petitioner noted that while it had already submitted its suggestions on the said timeline in the draft N90, the said suggestion had not been considered for incorporated 90. Petitioner's submissions regarding the said condition as stated in his letter dated 5/2/2024 are set out here in below. Condition time. A. The timeline of 21 for preparation and submission of techno-commercial bid fails to acknowledge the extensive nature of a project of this magnitude, particularly when undertaken on an EPC turnkey basis. Preparation of a techno-commercial bid would at the very least entail comprehensive efforts and steps towards site survey and investigation. But site survey and investigation is part of the post-award. Then 2, preparing a preliminary basic design.
Anyway, he wants so much time because of these components.
Yes. These components are post-award. If you get it, you can do it.
They're all performance that way.
And my lord, C is very relevant, my lord, in this. I'll just point it out and leave it at that. Coordination with E&M and HM contractors and soliciting their feedback for the design of civil components, which can be estimated to take at least 90 days. Now, my lord, your lordships have seen these various terms of the tender document. Then, my lord, there is a pre-bid meeting. We, as I indicated, your lordships, my lord, we raised some 74 questions. We were in a maximum number of queries we raised, and clarifications were given one way or the other, satisfactory or not satisfactory. And we submitted our bid. Yes, correct. That is a page 18 onwards. Now, my lord, please be kind enough straight away to go to page 18 onwards. See the heading at serial number 17 in our list of dates.
Page number?
My lord, our list of dates, my lord, list of dates. From serial number 17 onwards.
Yes.
Your lordships have seen, my lord, that the NIT was issued on 2/2. I have shown to your lordships, my lord, how
17 at page 5.
Yes, yes. Yes, my lord. Your lordships have seen, my lord, how after draft was issued, they corresponded with White. Now, my lord, I am showing to your lordships how they have corresponded with E&M manufacturers after the tender was issued. Please be kind enough to turn to serial number 18. Email from Andritz to appellant regarding E&M collaboration.
15th February, 8th February.
And 15 February.
5th February, 8th February, 15th February.
Yes. So, pre-tender, post-tender,
Where is pre-tender?
pre-tender is that pre-tender, my lord, was issued on 9/1. And they wrote to White on 25/1 pre-tender. After the pre-tender notification was issued. And from 9/1, and admittedly they were in contact with all of them from 9/1, which is evident from the letter of 5/2.
If 9/1 is for limited purpose taken at the reckoning date, what would be the period, number of days?
9/1, my lord, it will be
3 February.
Yes, 9/1, and the tender notification was 2/2. The last date was 23/2. So 9/1 to 23/2.
Almost 90 days.
Yeah, for L&T special privilege 4/3. If you, yes. If according, even according to them, if they are negotiating from 9-1 to 23-2, and so far as L&T is concerned, up to 4-3. Where is the basis for this grievance that I don't have enough time?
Any high court, any of the high courts in the country or the apex court said, while deciding the reasonableness of the period relatable to 17 or the pari materia provision in the respective states, even pre-bid exercise period also can be looked into.
My lord, I must confess, my lord, I have not seen it. If there is anything, I shall place it, my lord. As of today,
from your side,
no. As of today, my lord, I am not able to see it. No, his lordship said there are other states also, similar provisions. I don't know. I must confess, my lord.
KTTP like statutes are there in many.
Many states have it. Some states don't have it. They fall back upon Article 14. But I must confess, my lord, in answer to your lordship's pointed question, I must say, my lord, I have not applied. If there is anything, my lord, we will continue our.
But 17, 1, 2, 3, they speak of the period mentioned in the tender document itself.
Yes, correct. This is, my lord, only to point out to your lordships that even on the broader principle of fairness, competition, all this, and to show to your lordship that the object of the appellant coming before the court under 226 is not to vindicate a real right, but is with the oblique intention. They had enough and more time to do all this. Even if they stand that this such a complex project requires a lot of time, you say you had the time. You have been working on it.
And there, that apart, what you say is even time was given even during the pendency.
Pendency, that
is your contention.
So if all this been done, yes.
Other contention, so that we can put the things in focus.
Yes.
And save your time also.
Yes, ma'am. Yes, I understand, ma'am. But I don't think on this, Lord, I want to spend more time, because in our list of dates, Lord, at serial number 18 and 19, I have set out, Lord, how they have corresponded with Andritz, they have corresponded with Voith, they have corresponded with General Electric also. Please be kind enough to turn to page 468. I just show that to my Lord, and 467. Yes, my Lord, kindly turn to page 467. This is a mail that has come. No, yes. My Lord, 467 is a communication that goes. No, 1 minute. 468 is. I know. This is from GE.
This is from GE.
Yes. Which one? 468 is from GE to. No.
17th February, the third of the dates which is
My
mentioned.
Lord, I want your
18.
lordship to kindly see, my Lord, page 468, which is dated 15/2/2024.
This is with reference to column 18 of your
Yes.
short note.
Yes, my Lord. Yeah, you're also right. No, my Lord, it is with reference to para 20.
Para 20.
My Lord, 468 is a mail that goes from the appellant to GE. And what is very relevant, my Lord, is paragraph number 5 in that letter. Based on your experience
And the given level tender.
and the given level tender documentation, can you please confirm the minimum timeline that will be required for GE to prepare and submit a responsive techno-commercial proposal for the EM works to us? So they are inviting a techno-commercial proposal from GM to them, which will also include their internal techno-commercial conditions. And this is done on 15th of February. And your lordships will reckon this date of 15/2/2024 from 9/1/2024. Because they have been negotiating is what they admit. And at least from 2/2. What were they doing, my lord? And build up all this and then come to court in the last minute. Based on your experience and given level tender documentation, can you please confirm the minimum timeline that will be required for GE to prepare and submit a responsive techno-commercial proposal for the E&M works to us? As we are now open to adopt the MOU partner route instead of the JV route. So tell me the cost at which you are willing to supply the E&M equipments to us. Because this consortium became the supplier. And now, my lord, please see the response of GE, which your lordship gets at page 467. At serial number 5. This is the mail that comes, my lord, on 17/2 from GE.
Read para 1 also.
Yeah, sure.
Uncertainties forces us to wait and watch. Just above para 1.
Really? Yeah.
Then beginning of the letter.
At page?
Same page.
467.
In continuation to the discussions we had in the pre-bid meeting at page 467. The second paragraph, my lord. That's what my learned friend wants me to point out, your lordships. In continuation to the discussions we had in the pre-bid meeting of Sharavati PSP held at KPCL office at Bengaluru last Wednesday, the following points raises a lot of uncertainties and forces us to wait and watch. Yes, it is wait and watch only. They're right. Let us see how it happens. Then I will suitably mold the commercial terms between us. Let's wait and watch. No, this wait and watch, the court cannot be made a party.
G has written this, not me.
Yes, yes. It is all this is done, my lord, and then writ petition is filed, and they produce all this. Then kindly see para 5. GE standard time for preparation of a techno-commercial bid of this magnitude is 8 weeks. But there are exceptions which requires a lot of intervention of leadership teams of both the parties with a clear strategy, high winning probability, and clear mitigation of risk. Negotiate with them. That is the point, my lord, mitigation of risks.
And leadership strategy.
A leadership strategy is between L&T on the one hand and GE on the other. But we don't know, there's a very complex thing we have to sort out between them.
Verify that we were able to get it.
We were able to do it.
Other bidders were able to do
And the two other bidders have done it. So why can't they do it? Obviously, my lord, they were trying to make it possibly because it is L&T, so they want to have a more better bargaining terms. And then kindly see the last paragraph, my lord. That's very important. Further, we noted the query raised by L&T during the aforesaid pre-bid meeting, where L&T required whether KPCL shall allow E&M bidder to submit multiple E&M MOU with different E&M manufacturers, so that L&T can select their E&M manufacturer later after award, which in fact directly contradicts L&T's proposal to GE to work on exclusive basis for Sharavati. Now, this is the whole thing. What they came and told KPCL was, can we enter into contract, with many E&M suppliers, but finalize later on? GE is saying, what are you saying? You are telling KPCL that you want to have multiple agreements.
You are contradicting yourself.
You are contradicting yourself and now coming and telling me this. This is the confusion they have created for themselves in their relationship with GE. Obviously, my lord, they went and told GE, we want you. They went and told KPCL, no, we will enter into contract with many others. And GE is saying, you came and told us one thing. You are telling KPCL some other thing. I don't think this is very complimentary to them, to the way they are doing business. Anyway, my lord, that's their prerogative. I will stop short of saying that the court must not be dragged into this unsavory commercial discussion between GE on the one hand and L&T on the other. Anything else? Lord, I think, Lord, with this I have placed all the facts, and in the note, my lord, at page number 7 onwards, I have put the propositions also in the synopsis, and these are the propositions. And at page number 8, we have put, my lord, the list of authorities. I want, your lordships have already seen Raunak, my lord. I want your lordship to be kind enough to see the judgment, my lord, in association of registration plates versus Union of India. This is with respect to that security plates, my lord, for the cars. If your lordship will be kind enough to take that judgment, my lord, give the association.
That in the light of attack on parliament.
Yes. And my lord, there, my lord, they say, how far can the conditions of a tender document be looked at by the court? If your lordships are kind enough, my lord, to turn to para. But I am given to understand it is the judgment that has been filed along with the compilation of respondent number 1. And in that, my lord, I want to point out your lordships para 28. Para 3, is it? Yeah.
Foreign collaboration.
Now, please see para 3, my lord, of this judgment.
Page number?
My lord, it is available at page number 13. Running page 13 of the compilation filed by respondent number 1. This tailor-made contention was also made before the Honorable Supreme Court in this judgment, which your lordship will kindly see at para 3. The main grievance of the petitioner is that all notices inviting tenders, NITs, which have been issued by the various state governments contain conditions which seem to have been tailored to favor companies having foreign collaboration. The tender conditions are described to be discriminatory in Article 14 of the Constitution, being aimed at excluding indigenous manufacturers from tender process. In all the cases, the grievance is that the work of supply of high security registration plates for all existing vehicles and new vehicles is being entrusted a single license plate manufacturer in a state or region and for a long period of 15 years, thus creating monopoly in favor of selected bidders to the complete exclusion of all others in the field. The contention advanced is that the creation of monopoly in favor of a few parties having connection with foreign concerns is violative of the fundamental right of trade and commerce and Article 19(1)(g). So tailor-made argument was advanced. Now, my lord, please
Where
be
it
kind
is
enough.
treated?
My lord?
Where it is treated?
My lord, at paragraph number 28. Para 28, there are 2 paragraphs, my lord. You kindly turn to page 21. Para 20.
At page 20.
28.
Page 20.
28.
Further. The further contention.
Paragraph you want me to see. My lord, kindly see para 28, my lord. It is at page number 22. Why have you put 21 here? My lord, I'm given to understand, my lord, that my lord, I just show para 28 and then go to para 38. It is submitted. Your lordship gets it at page 22. It is submitted that the tender conditions are formulated keeping in account public interest considerations and aspects of high security. The states do not possess the requisite resources of their own to implement the scheme. Each state has therefore to search and select a dependable manufacturer. It is submitted that the tender conditions specifically require the manufacturer to conform to the technical specifications of high security registration plates. It should be able to prove existence of requisite financial resources to integrate a large number of RTOs in the state on an online platform. The manufacturer should have the permanent technical partner to the venture so that the technology support is assured for the entire period of contract. Manufacturer to be selected should have access to the requisite technology and should be in a position to upgrade, expand, and upscale the operation on a continuous and sustainable basis. It is necessary to have a long-term contractual relationship so that the state can fix liability on the manufacturer and make him answerable for damages or any defects in the registration plates or for improper implementation of the project. The requirement of rule that registration number and plates will be issued on premises of RTO is to maintain secrecy and security. For the above purpose, selection of one single manufacturer will ensure security aspects instead of more than one manufacturer operating from different fleets. Now, my lord, please be kind enough to turn to para 38.
Para 38. In the matter of
Yes,
formulating.
in the matter of formulating. My lord, it is at page 26, my lord. Your lordship. In the matter of formulating conditions of a tender document and awarding a contract of the nature of ensuring supply of high security registration plates, greater latitude is required to be considered to the state authorities. That is, my lord, the famous term that has been used with the courts, play in the joints. Unless the action of tendering authority is found to be malicious and a misuse of its statutory powers, tender conditions are unassailable. On intensive examination of tender conditions, we do not find that they violate the equality clause under Article 14 or encroach on the fundamental rights of class of intending tenderers under Article 19 of the Constitution.
Should be left to the executive appears.
Exactly. On the basis of submissions made on behalf of the union and state authorities and the certification shown for the terms of the impugned tender conditions, we do not find that the clauses requiring experience in the field of supplying registered in foreign countries and quantum of business turnover are intended only to keep indigenous manufacturers out of the field. That's, my lord, what your lordship asked me. Tailor me. It is explained that on the date of formulation of the scheme in Rule 50 and insurance of guidelines thereunder by the central government, there were not many indigenous manufacturers in India with technical and financial capability to undertake the job of supply of such high dimension on long-term basis and in a manner to ensure safety and security, which is the prime object to be achieved by the introduction of new sophisticated registered plates. The notice inviting tender is open to response by all, and even if one single manufacturer is ultimately selected for a region or state, it cannot be said that the state has created a monopoly of business in favor of a private party. That's all, but only two grounds: malicious or misuse of statute, nothing else.
And this is the condition within the tender work area.
Yes, this is it.
And here it is outside the tender.
This is outside. Exactly.
Argue that.
That's that. I will. Yes, sir. In fact, I'm on a better footing. I'm on a better footing. Then, my lord, of course, my lord, the judgment, my lord, of Michigan Rubber, which your lordships are aware, my lord, which we have, that tender conditions and scope of judicial review very limited, my lord. Michigan Rubber, I'm not going to detain your lordships on that. Where is that? What is this? Oh, okay. My lord, is the first judgment in the at page number 1 of your lordship's compilation, my lord. And if your lordship will be kind enough to see para 9. It is a fairly recent ruling of the Honorable Supreme Court. If your lordships are kind enough to see para 9, my lord, at page 4 of the same compilation, my lord. Same compilation, no? Same compilation. Same compilation.
Balaji Venture.
Yes, yes. Para 9 at page 4 at the bottom. Now, so far as the impugned, I'm sorry, my lord, I apologize.
Yes. Before we consider. Same?
Well, no, para 9, my lord.
9. Now so far.
Now, so far as the impugned judgment and order passed by the High Court dismissing the writ petition is concerned, what was challenged before the High Court was one of tender conditions clauses. High Court has specifically observed and noted the justification for providing clause 1.125. The said clause was to be applied to all tenderers bidders. It cannot be said that such a clause was a tailor-made to suit a particular bidder. It was applicable to all.
Because it was open to everyone.
Open to everyone.
That page para 43 of the other judgment.
Yes, exactly. It was applicable to all. Owner should always have the freedom to provide the eligibility criteria. This is important, my lord, what your lordship told me. The owner should always have the freedom to provide the eligibility criteria and or the terms and conditions of bid, unless it is found to be arbitrary, mala fide, and or tailor-made. The bidder tenderer cannot be permitted to challenge the bid conditions clause, which might not suit him or convenient to him. As per the settled proposition, or as such, it is an offer to the prospective bidder to complete and submit a tender, considering the terms and conditions mentioned in the tender document. He can't make it. It's not even a counter offer. When bid is issued and he submits a bid, it's not a counter offer because mine is not an offer. Mine, I say KPCL is not an offer. So where is it? Therefore, my lord, my respectful submission is that all grounds, the writ appeal should be dismissed with respect to submission and make. I'm grateful to your lordship for giving me so much of time. But there is one other last submission I want to make. Now, my lord, there is one difficulty that is, now that the contract has been awarded in favor of respondent number 2, there's one practical difficulty I want to place, and I will leave it. I will place my difficulty and leave it with your lordship's for a solution. Now, my lord, we are entering in a monsoon season in the Western Ghats, where this project is. Now, my lord, if between now and June, for some reason, and on account of the stay that has been granted pursuant to the letter of award, no work can take place. Then, my lord, what happens is, for the next at least 8 to 10 months, there can be no work. And because there will be 2 monsoons in Western Ghats, my lord. Plus, my lord, what happens is, after we have done after this initial survey and all has been done, after the survey is done, we have to submit, my lord, a proposal to the KPCL as to the extent of land required. Some portion of land may be government land, some portion of it may be private land, some portion of it may be forest land, which will require then, my lord, the MOE of approval. So, my lord, that is the reason why, my lord, we moved an application for vacating stay also. This is the difficulty, my lord. Otherwise, this whole project will get delayed by a couple of months. Right? 1 year, my lord, will get delayed.
But how?
I'm in your lordship's hands.
We have heard, almost heard the matter.
Yes, I'm in your lordship's hands. How to find a solution for that problem? My lord, of course, because I cannot cross, my lord, beyond
We
this.
don't find solution, we will deliver judgment.
My lord?
We don't find solutions, we deliver judgment.
My lord, I know your lordship. I can't say anything on that, my lord, because my boundary stops here. Man.
Yes, Lord, your lordship saw, my lord, the last of the judgment, because only one. Then, my lord, I'll come to, my lord, AG's submission. Please take, my lord, the last of the judgment which my learned friend read in that compilation of judgments which was given by the learned Advocate General. This, my lord, judgment, the first judgment, my lord, which was read to your lordships. Please look at paragraph 9, page 4.
Now, so far as.
Yes, it was, my lord, please come to, my lord, 1, 2, 3, 4, 5, 6, 7 lines. It was applicable to all owners, should always have the freedom to provide. Owner should always have the freedom to provide eligibility criteria and the terms and conditions of bid, unless it is found arbitrary, malified and tailor-made. If it is arbitrary, definitely, my lord, the terms are amenable for. Then the other judgment, my lord, as far as that number plates are concerned, please see, my lord, what is it? Please come to, my lord, page. My lords may come to, my lord, page 26. That was a case, my lord, where paragraph 38, line number 2, high security registration plates, greater latitude is required, my lord, because, my lord, high security number plates, my lord, stands on a totally different footing after the Parliament attack. And this is in the context of that. And, my lord, every place, if your lordship now come back to, my lord, my learned friend, read to your lordships, my lord, paragraph 28 at page 22. Again, my lord, the same thing, high security. Line number 2 at page 28, para 28, page 22. Account of public interest aspects of the high security. So, my lord, that stands on a different footing. This judgment has to be read in the context of, my lord. That's why, my lord, the courts have time and again held. Fact situation, my lord, make the law. Now, my lord, let us look at, my lord, what is it that the Advocate General first argued. Then, my lord, I'll refer to, my lord, Raghavan's. First submission, my lord, that was made before your lordship sees. I needed clarification whether, my lord, it was MOU or JV. Therefore, he was waiting, my lord, for the MOU. My lord, please come to page 125 of volume 1. There was no uncertainty. Sorry, volume 2, my lord. Sorry. This is, my lord, the tender.
Page number?
Page 125, my lord. The tender begins at, my lord, page 115, 115, at 125, serial number 2, my lord, 15. Paragraph 15 or what a column number 15.
Last date for
receipt of queries. We, my lord, sought queries as to whether MOU or, my lord, JV can be, my lord, permissible. And see, my lord, what is it that they said? They said, volume 4, if your lordships come to, yes, MOU is permissible. And my learned friend, my lord, the Advocate General said, oh, they were, my lord, waiting, my lord, after the writ petition to negotiate with the MOU, my lord, because that was not clear. No. Please come to page, my lord.
From this, what will be give or take?
the argument of the learned advocate general was, my lord, I'm sorry, what his arguments were twofold. One, that, my lord, the clarity was not there as to whether, my lord, this is, my lord, a project where there is a civil engineer and, my lord, an electrical and mechanical engineer. They are two together, my lord, to be done. Argument was, I was waiting, my lord, for clarity on the MOU. And, my lord, the MOU, my lord, I will now negotiate with them, my lord, for MOU. That clarity is not there. Therefore, I wanted more time. Answer is, my lord, apparent MOU, my lord, was permitted. It was permissible. I did not, my lord, wait for that. Yes. Please come to, my lord, running page, volume 4, 706. Clarification was given by the KPCL itself.
Page 716.
My lord, it starts at no, 706, my lord, if your lordship sees. Sorry, not that, my lord. Yes. My lord, I'm sorry. Page 445. Volume 3, my lord. Sorry. Volume 3, page 445. Please look at, my lord, clause serial number 193. That was a clarification sought. All of us sought. Please look at, my lord, KPCL's reply. 193 on the last column. For MOU partner only, for the technical capabilities will be considered. So MOU is permissible. Then 194. MOU would be considered for the other equipment, control, protection, equipment, KV, gas insulation. So, my lord, MOU was permissible. The argument canvas was, there was no clarity. Therefore, my lord, I was trying to find out, my lord, whether I could enter into MOU, all that. That is not the issue at all. That's a non-issue. Secondly, my lord, the contention that has been canvassed is these are the queries, my lord. 270 queries were there. They replied, my lord, to all these queries on 17/2. My lord, please look at the timelines. 21/2 is the last date for submission. 17/2, my lord, they submit, my lord, they give this clarification. And on the same day, they give, my lord, the geotechnical report of, my lord, WAPCO on 17/2. 21/2, my lord, is the last date and extended by 2 days. Please have a look.
Report appears to have been given much earlier.
No, my lord.
Not earlier.
No, my lord.
It was
17/2.
given on only on 17/2.
Yes.
In response to bid queries.
And now please look at, my lord, what the KPCL itself says, my lord, because my learned friend, Mr. Raghavan, asked, my lord, started arguing as if, my lord, he appears to the KPCL. See, my lord, what the KPCL says. That is very, very relevant. Please look at their objection statement. 483. Please come to, my lord, page 483. Same volume, my lord, 3.
16, 17.
Absolutely, my lord. Geotechnical investigation, my lord, report is a very essential document. They give it on 17/2.
Para 18.
Yes.
They have it. That is the stand.
Correct. Correct. And my lord, it was available with them from 2021. And my lord, please bear in mind, this is, my lord, in the Western Ghats. Dr. Kasur Rangan's, my lord, report said nothing should be done in Western Ghats. My lord, they apply for the EC clearance and FC clearance. In the, my lord, in the tender, they say we have not yet applied. And it takes 6 months. Without all that, my lord, how do we, my lord, what is this hurry? I ask myself. That's why, my lord, arbitrariness. And I'll point out, my lord, a judgment of the Supreme Court where they say, what is arbitrariness? Project, my lord, please look at para 16, page 483. Project has been, my lord, on the anvil for more than a decade. Suddenly, my lord, before, my lord, the election code, my lord, comes into force, my lord, they want, my lord, everything to be done in a hurry. Geotechnical investigation for the purpose of determining the feasibility of the project, required environmental clearance at the highest level and so on, so is considered to be eco-sensitive zone. In view of the same, obtaining of such permission took considerable amount of time. After such permissions obtained when investigation was being carried out, there was an interim order obtained from the Honorable Court, which also hindered and delayed the project. Thereafter, complete details of geotechnical investigation, para 17. Aforesaid geotechnical investigation would be sufficient as per experts engaged in answering the respondent for the purpose of bidding. And your lordship saw, my lord, what was it? The report, my lord, is, it says we have not done anything about the tunneling because this is, the tunneling is the most important one. Hmm? My lord, volume 4, sorry. Is what you have written, I say. This is, my lord, if your lordships look at, my lord, the geotechnical report, my lord, give me that. Your lordships asked me, my lord, on the last occasion, the other bids, my lord, in respect of which, my lord, I have already, my lord, indicated, Rattle, my lord, Kaiga, all that. What was the tunnel length?
That Jammu Kashmir.
Yes, all that. We have it. In fact, my lord, this is the largest, my lord, 17 kilometers now. Just give it to you. Give the copies, I say.
No, just we wanted to know the depth of drilling.
Yes. First one, my lord, is 850 megawatts of Rattle.
I have objection to any new facts being told to your lordships. This is,
So,
I don't know if this is right or wrong.
My learned friend, my lord, gives your lordships, my lord, some
Tender
document.
document. No, 1 minute, please. I knew you say. I gave your lordships a page of the NIT. I did not give your lordships a new fact. Let's not make that.
Your lordships wanted them, my lord, a factual matrix.
No, my lord, that on this, if it is not there, it's not there. Today in the writ appeal, my lord, this detail cannot be given. I object to this.
Since your lordships asked me, my lord, I am furnishing this. It's up to your lordships, my lord, to decide. I leave it at that. All this, my lord, is a shorter length. This, my lord, is this. Now, please look at, my lord, the report itself. Where is that? Report, I'm saying. See, page 663. Please come to, my lord, page 663. Volume 4. That is the report. My lord, page 648, annexure A. Page 648 of volume 4. This is the report. When was it given? November 2021. They keep, my lord, the KPCL keeps it in their pocket, does not give, my lord, this. Only on 17/2 they submit this. And please look at this again. Please come to, my lord, 663. Para 1.4. The geotechnical, my lord, para 1.4 at 663. Geological and geotechnical investigation, lab-based rock mechanics tests have been carried out during the period 2018 to 2020 by WAPCOS, NIRM, CSMRS, New Delhi in DPR stage. In connection with the preparation of the detailed project report, detailed geological and geotechnical investigations required to be made. The project techno-economically feasible, eco-friendly without time and cost overruns, as well as to avoid geological surprises. Now, my lord, please come to my lord. What is it that they have said about the tunneling? 688, if your lords has come to. There are 3 different tunnels. As far as the tunneling is concerned, nothing has been done. They themselves admit. And my lord, I ask myself this question. Did they, my lord, when, my lord, we gave, my lord, if your lordships come to, my lord, the running page, at, my lord, 356 of volume 2. For other, my lord, projects, 120 days, 200 days. And here, my lord, 21 days for a larger, far larger project of 8,000, my lord, 8,000 crores and 2,000 megawatts. Now, my lord, please look at, my lord, what is it that they have said? Did they give any reason why, my lord? One of the argument that was canvassed was, oh, they have, my lord, given sufficient time. I ask myself this question. No reason, my lord, has been assigned in, my lord, in the entire proceeding. My lord, please take the proceedings of the KPCL itself. Please have a look at the KPCL proceedings. Not one whisper that, my lord, this is the timeline required. Non-application of mine to the core. My lord, please come to, my lord, volume.
Why do you say like that? Note sheet other day which you have shown 39, 40, 41.
Would your lordships again look at it in the light of the background, my lord, of the arguments canvassed by my learned friend? Please have a look at it. I may be wrong. Just, my lord, I will not take more than 2 minutes on this aspect. Please look at, my lord, that volume, my lord, 3. Entire note sheet, my lord, is page 504 onwards. The only reason, my lord, your lords will get is page 517. Let us again look at, my lord, para 39, but please look at para 34 for a minute. To expedite, sorry. Page 517, bottom, note number 34. To expedite the implementation, my lord, there is nothing, no reason given, my lord, why, my lord, all this is needed. To expedite the implementation, Saravati PSP, it is proposed to invite short-term tender by adopting observations of STPC. Now, please turn the page over. Para 39. Please have a look at it. 3 paras for kind perusal. Para 38 may be kindly be approved. Para 38 says approval. No reason is given, my lord. How much of time is needed? Is, my lord, this time sufficient? Ultimately, my lord, arbitrariness is, my lord, is what we are looking at. 17 to, my lord, they give, my lord, the clarification for 270 queries. The report of, my lord, geotechnical report, my lord, is given on 17.2. In the entire body of, my lord, this, no reason is assigned as to why, my lord, they are giving, my lord, only 21 days when, my lord, projects of far, far, my lord, lower magnitude, time given, my lord, is 120 days, 200 days. Therefore, my lord, my submission to your lordships is, and my lord, please look at the board minutes. Please come to page 527. Para, my lord, 2 was read to your lordships, para 2 and 3. It was only with regard to, my lord, the cost, not with regard to the timeline. Please have a look at it. There is not a whisper. What is not there, my lord, I can't show to your lordships. There is not a whisper with regard to, my lord, the timeline. How much of time is needed? It's all regard to costing. In fact, my lord, there was a change from the draft, my lord, tender and, my lord, the final tender. Earlier it was 6,000, it became 8,000. Except this, my lord, entire, my lord, note sheet, there is no, my lord, whisper of, my lord, with regard to the timelines, except, my lord, as I pointed out in paragraph, my lord, 34, where they say short-term tender, my lord, will not in mind. Why, my lord, that short-term tender? For 10 long years, it has been, my lord, on the anvil. My lord, I asked myself this question. Ultimately, my lord, one of the arguments that they can was everything is to be done later. My submission is, I will point, my lord, please look at this, my lord, again, 527, not one whisper in the entire body. Either, my lord, in the note sheet or here, and, my lord, for the first time, in the note sheet, my lord, in the list of dates that my learned friend gives, he says there was some technical committee, my lord, issued by the scrutiny pre-tender committee, some retired high court judge, my lord, high judge, not even high court judge, high judge. Not this. KPCL doesn't say that. KPCL, my lord, there's.
Judge is a judge.
Anyway, my lord, now. Then, my lord, coming to, my lord, my learned friend's arguments. His argument is, one, that, my lord, he refers to, my lord, clarification sought by me, my lord, at page 359 of volume 3.
Yes. $359.
Yes, ma'am. Para 360, my lord, page 360, volume 1, paragraph 5, subpara 1. He refers to all this, site survey, all this, according to him, my lord, these are all subsequent event. For the purpose of, my lord, costing, my lord, please look at it. How much area is needed? What is the tunneling length? Whether, my lord, it is in, my lord, hard strata, my lord, soft strata, because if your lordships are aware, even, my lord, without any knowledge of engineering. Sorry.
Yes, yes.
What you say is, we understand, what you say is, even to make a rational decision as to whether I should participate
No.
or not, I should have
not only that,
all these factors.
Not only that one, costing, please look at it. If it is, my lord, in soft strata, then, my lord, the tunneling, my lord, work. Then, my lord, tunneling is, my lord, done by, my lord, either, my lord, chiseling or, my lord, the tunneling machines. If it is in soft strata, it, my lord, takes, my lord, far less. My lord, it's virtually, my lord, not even 10% of the cost. If it is in rock, hard rock, it is, my lord, totally different. It is 10 times more. How does, my lord, one arrive at the costing? That is why, my lord, in all these tunneling projects, time given was, my lord, 120 days to, my lord, 250 days. And ours is, my lord, 3 times, my lord, larger than the other tenders that were invited and, my lord, work carried out. Therefore, my lord, my submission to your lords is there must be a rational application of mind. Reasonableness, my lord, with regard to the timeline, my lord, has to be looked into. In the entire body, my lord, they have not looked into it. Therefore, my lord, my submission to your lordship is, then, my lord, their argument, next argument is, it was given, my lord, earlier, because January itself, my lord, that draft was in circulation. Can I persuade your lords to look at, my lord, that draft? Ultimately, my lord, all that was 6,000 crores. And, my lord, the full particulars are not given. What happens is, whether, my lord, it is a hard strata or a soft strata, whether, my lord, the work involves, my lord, into, my lord, subterranean, my lord, whether, my lord, the latitude and the whether, my lord, it goes deep down or, my lord, it is only in the surface level. All these are aspects, my lord, which must be looked into, at least for costing. One minute. My lord, should I continue? I'll take another. I'll be as short as possible, as brief as possible. I know, my lord, your lordships have been very, very indulgent. I will
We can finish it in another 10 minutes.
It'll take at least about 25 minutes, my lord, if your lordships permit me. Sorry, I shouldn't eat into your lordship's lunchtime.
No, no problem.
I know, my lord, that in the 1 hour, lunchtime will be only 5 minutes. Your lordships will have number of other work.
So you'll complete within 15 minutes.
Yes, my lord. I'll try and, my lord, do that. Definitely, I know, I understand, my lord. Your lordships have been so kind and indulgent. We must also be, my lord, cooperative.
Other body is not detained. Rest of the body is also long, so you.
I know, I
Yes,
know,
my lord, yes.
I know that. I know that. I am
Course,
acutely
my lord.
aware. Please, my lord. Though my learned friend took 2 hours, my lord, I will not take, my lord. Please, my lord. mention ಮಾಡಬೇಕಾ? ಬನ್ನಿ ಈ ಕಡೆ. On the mic. Here.
Because of this order, large number of generators in the state are now wanting to supply power, supply it outside Karnataka. So this is a critical month for us, Lord. We need some protection. Section 11 order was issued. By virtue of that order, my lord, they had to supply within the state.
So you granted stay.
They are seeking, my lord, interim order. It has not reached, my lord. It has been on board.
My lord, could
No
this,
interim order is granted as it.
Not yet, my lord. It's on board.
my lord, could this be taken along with FR number 569 of 24, my lord?
Lord, state has also filed, my lord. In my case, if your lordships are pleased to, my lord, grant some relief, that will follow, my lord.
Yes.
Yes,
Has also
it's a
filed-
similar,
That's not ready yet.
That's why I'm giving the FR numbers.
no.
Yes,
Whereas in the, Mr. Naganand's matter is taken up, Malas, the same state is supporting Mr. Naganand, Malas. It's a section 11 order issued, Malas, where the state has issued so that there's shortage of power in the state, Malas. In fact, your lordship were pleased to pass an interim order fixing the price at 7 rupees 20 paisa in writ appeal, Malas, pursuant to which your lordship had directed the single judge to hear the matter.
You can move on this vacation.
Vacation bench.
Some urgency, my lord. If your lordship give me just 5 minutes at the end of the day today, or I won't take more than 5 minutes.
This is
I'll
totally
wait and see.
completely fresh matter.
Yes.
It is completely fresh matter.
Yes, my lord, fresh matter. It has appeared on board more than once, my lord, but because your lordships are busy with this case.
We'll try day after.
Day after. Thursday then. Thursday. 25th.
25th.
Please.
My lord, could it be
Lordship,
called with,
kindly- Could it be, my lord, the top of the board if possible?
We'll try to take.
Only reason is not the entire state is being affected by this, because between the date of the order, the learned single judge and now, we have received more than 50 applications from generators to say, we don't want to supply to state, we want to supply outside. And the order of the learned single judge, my lord, enables them. Otherwise,
Okay.
we'll file contempt.
Again, tender matter.
No, my lord, it's a supply of electricity. Lord, we are the state body, my lord. The generators in the state are seeking permission to supply outside the state. And the state's order says you should supply within the state.
The lordships are hearing this matter, Malas, where we are issued, because of shortage of power, we had to do this matter, tender matter, Malas. One of the reasons is issuance of section 11, Malas. This is related to.
Council comes, we find it and done it. All right, 25th will take up. Try to take up.
along with the FR number 569 of 24, my lord.
Where state has it's the same.
But then why not 24th? You are not here on 24th.
I have some difficulty on 24.
25th.
State of the laws.
Obliged, my lord.
Listed with writ appeal number so and so, which is a cognate appeal. Cross up. Cross up.
Well, my lord, regular
Cognate
appeal.
appeal filed by the
Same order. I am one respondent, state is the other.
cognate.
My lord, I've given the FR number, my lord.
But translation, at least basic documents you file.
Yes, my lord. I've complied with everything. Whatever office objections are there, we are ready with filing, Lord. I'll file it in the office. Translation, sorry.
Obliged.
Lordship, serial number 31, your lordship, contempt matter, wherein this court directed specifically no time can be given for their filing response, because almost entire lake of 72 acres has been destroyed, Malatali Lake. Now, today, yesterday also went there, completely all the fences are removed and roads are being formed, and they don't file a response. And last again of the 3rd April, specifically your lordship passed an order, it is the last chance we are going to give, no further time. Today also they are not served any
Contempt.
copy of the response, contempt.
Contempt.
Some accommodation, because today, because I don't want to say anything on that. Because 44 acres of water should be preserved. We are facing problem in Bangalore.
If you mention for urgency after vacation.
Immediately after vacation. Immediately after vacation, some date may be.
If you don't mention.
Because I don't want again, I know the last 3 working days. Because they are not filed the response, that's what responsibility.
Third.
In fact, I served the copies to them.
ಆಯ್ತು ಒಪ್ಪಿದೀನಿ. ಮತ್ತೆ argue ಮಾಡಿದ್ರೆ time waste.
Please, publish.
Serial number 2.
Lord, in order to shorten my lord the arguments, we also prepared one brief synopsis kind of a thing. Because may not be that brief, my lord. Lord, first of the submission, my lord, my lord, as your lordship, my lord, rightly pointed out, I must be within that 15 minutes. First of the submission was work done after, my lord, all these works were to be done after the award. In the note, my lord, what I have said is project commencement not reason for the KPTSL's hurried action, my lord, page number 1. And I have put an index also, my lord. You have given it. I have put an index, my lord, what it is, where, my lord, it is in the very first page, that is 0 page. 1, my lord, your lordship sees project commencement not even the reason, my lord, for KPTCL's hurry. 10 years, it's been, my lord, in the annual. Approval, my lord, for the project report itself was on took 3 years, my lord, for WAPCO. And, my lord, geotechnical report, my lord, shows, my lord, that, the major portion of it, tunnel, nothing is done. My lord, unless one looks into it, it's just not possible, my lord, to arrive at, my lord, financials. So I should have argued then given this. Please. So I was holding on.
It's a project for storage of power, not electric power generation.
My lord, what happens is water is stored, then, my lord, water is pumped out for generation. At the critical stage, my lord, supposing summer, my lord, there will be that storage. So, my lord, the water is pumped out, the generator will generate electricity and then it is given. Therefore, my lord, it is not
Purely
electricity-
power generation
Correct,
project
no,
it is.
no. It is, my lord, for the, because, my lord, as your lordships are aware, electricity can't be stored at all. My lords are aware, my lord, the Honorable Supreme Court also has held, my lord, in several judgments that electricity can't be stored.
Alternate current.
That's right. It is, my lord, it is instantaneously, my lord, consumed. Therefore, this is, my lord, storage of water in underground, and then, my lord, it is pumped out. So that, my lord, at that stage, electricity is generated. Therefore, this is not, my lord, generation of electricity as such. It's storage of power virtually.
The generation comes storage.
Generation, my lord, is later.
Comes storage.
It is,
Principally storage,
yes.
incidentally generation of power.
That is, my lord.
Or both.
Both.
Look out that. Clause 17. No, 772.
Renewable. Don't consume together. Same water.
Lord, one other submission that was canvassed before your lordship sees, work to be done afterwards. Can I seek your lord's indulgence? Look at, my lord, volume 4, page 635. Can I give your lordship, my lord, just illustration first? My lord, Vidhana Saudha, my lord, is to be constructed. They call for a tender. Unless we know, my lord, what is the width and the breadth and, my lord, the depth to which, my lord, we have to go, what is the foundation, what is the floor area, my lord, how many rooms are to be there, and, my lord, the soil, whether, my lord, it's a hard soil, soft soil, or, my lord, what happens is, if it is a soft soil, we'll have to go down, my lord, deeper. If it is a hard soil, my lord, there is no need. So, my lord, unless, my lord, these details are known, it's impossible to give, my lord, the financials. Now, please look at, my lord, what has happened. Can I request your lord to turn to, my lord, page number, please come to, my lord, page 8. Please look at 18, serial number 18. Look at the date, my lord, when it was awarded to him. In a matter of 2 days.
Page
1/8, my lord. In my list of
All right. Corresponding number will be 646.
yes.
646.
No, my lord, page, no, my lord. Page 8 of
In your
no,
notes.
sorry, my lord, my profound apologies. Okay. My profound apologies. ಕೊಟ್ಟಿರೋದು ಇಲ್ಲ ತಾವು ತಮ್ಮ ಹತ್ರನೇ ಇತ್ತು ಅಲ್ಲಿ ಲಾರ್ಡ್ ಪ್ಲೀಸ್ ಕಮ್ ಟು ಸಾರಿ Lord, I must owe an apology to your lordship. So many papers we have given.
No.
So sorry.
Case itself is like that.
Lord, please come to page 8, serial number 18. On 6, my lord, there was an interim order throughout. On 6/3, my lord, please look at the tabular column. 6/3, impugned order came to be passed at 2:30 in the evening. Afternoon, between 2:30 and 3. 7/3, my lord, they exchange. 8/3 is a holiday, 9/3 is a holiday, 10/3 is a holiday, 11/3, my lord, awarded. My lord, in a day, they have, my lord, already, my lord, technical evaluation is done of such a mega project in 1 day. Please look at, my lord, the malice. That's why, my lord, we have spoken about malice. 1 day, an 8,000, my lord, crore project is, my lord, evaluated, financials approved, my lord, award given. And at a stage where I moved your lordships on 7, your lordship said your lordships will take it up, my lord, on Monday. And, my lord, on Monday morning, they say we have given it. This again, my lord, shows acute, my lord, arbitrariness, my lord, to the core. Please look at, my lord, our rejoinder, my lord, if I can take your lordships, my lord. Sorry. In this regard, what is the work to be done? My lord, please take, my lord, my page, my lord, volume 3, my lord, if your lordships take, my lord, volume 3. Volume 4, is it? Volume 4, my lord. 635. No, correct. Ten is not needed. Para 10, my lord, 633, volume 4.
In the
In the-
present circumstances.
Yes, my lord. In the present circumstance, geotechnical analysis which the petitioner should be required to undertake, as mentioned in the previous paragraph, is not a detailed geotechnical investigation as was conducted by WAPCOS. Respondents' contention in this regard, included paragraph 6 of the reply, are based on misunderstanding of petitioner's case. Said geotechnical analysis would primarily entail visual inspection, assessment for determining geological conditions, studying the rock outcrop near the project component, drone survey for visual inspection of inaccessible area, detailed contour survey of major project component, that is portal intake outfall area, understanding access, approach road, conditions, inspection, geological conditions, seismic refraction, tomography, all that. Then please come to para 17. All this is required to be done before. Afterwards, design, yes. It's like, that's why I said, Vidhana Soda, if they say construct Vidhana Soda, unless details are known, how do we give the financials? And all this done in one day, as far as the mega is concerned.
Yes.
Therefore, my submission to your lordship is last 3 lines, in that para 17 itself, page 635. Analysis of geological data which would indicate the nature and extent civil and engineering work that would be required to be done, thus aiding in the calculation of the bid price that can be offered. Therefore, my lord, and we have given, my lord, the volumes, which are the annexures that we are relying upon, all that. And there is no, my lord, as far as this is concerned, there is no reply, no argument. Ultimately, my lord, it is this. That's why I submitted, and that also, my lord, they have not. Major projects, my lord, which are not even half the size of this. 120 to 254 days, my lord, time, my lord, given for, my lord, submission of the bid. Reason is, my lord, it requires that much of time. It's not, my lord, done, my lord, overnight, and nothing, no details are given. WAPCO report, my lord, they themselves, my lord, in the morning I submitted to your lordship. KPCL objection statement itself says geotechnical report, my lord, is absolutely essential. They gave it to us on 17/2, and that, my lord, does not, my lord, it says the tunneling, my lord, we have not gone into it because it's inaccessible. Then, my lord, how do we give, my lord, the financials? So we have to study. That takes time. That's all that we said. Give us 90 days from the beginning, my lord. All tenderers, my lord, said, bidder said, we want time. Even, my lord, Mega said, we want time. Out of the 3, my lord, one of them did not even attend the pre-bid conference. Therefore, my lord, these are the issues, my lord, which arise for your lordship's consideration. Arbitrariness. Is there arbitrariness, my lord, in the process? If it is, your lordships have the power, my lord, to interfere and
yes.
Lord, can I also persuade your lords to look at paragraph 7, my lord, of the same volume, my lord, if your lordships come to, my lord, page 631. 631.
Yes.
It is denied that there were detailed discussion on 23rd and 24th of January in relation to the geotechnical investigations. There was no scope for any detailed discussion of geotechnical aspects in the absence of geotechnical report being available with the petitioner, which, my lord, was made available only on 17/2. Said geotechnical report was admittedly made available only on 17/2. Respondent has made several misleading submissions in relation to the geotechnical investigation and site visit to paint a false picture on how the process works. Planning, design, construction of the project which involves underground construction and activities such as the present project is generally faced with uncertain subsurface conditions, involves significant geotechnical risks. In such projects such as the present one, geotechnical investigation report is generally furnished by the tendering authority along with the NIT, which the bidders are required to, my lord, rely upon, and then, my lord, give their financial bids. And, my lord, can I also persuade your lords come down, my lord, to in the middle, 2nd of February, your lords get that. I did, my lord, go on 2nd of February, yes. Merely, my lord, a preliminary visit done to understand the topography and to get a sense of accessibility and approachability to the area could never arm the petitioner with the information able to, my lord, prepare a techno-commercial bid. Geotechnical report, my lord, is a starting point. 17th they give. 21st, my lord, is the last date. And even that I submitted, my lord, it is not, my lord, does not indicate anything. Insertion. My lord, sorry, 19 days and 21 days. If your lordships, my lord, just look at the note, my lord, or the KPCL, my lord. I'll tell your lordships why. Whether, my lord,
Pursuant to corrigendum.
Yes, my
of 17 February. 17 February.
Not that, my lord. The note sheet of KPCL.
Note sheet.
Yes, please have a look at page, my lord, 525.
You read note 31, 38, 39, 40,
Yes.
41.
Can I persuade your lordship? Just look at it. I'll tell your lordships why. One aspect, my lord, which I had not brought your lordship's notice. Please have a look at it. 525, my lords, get that at, my lord, volume 3. If your lordships look at, my lord, it's at the top, 525, volume 3, my lord. 17-2, my lord, it's dated 17-2. My lords, get that?
Reply to the queries are to be.
No, my lord, absolute top, my lord. My lords, get this here. 17-2. It's dated 17-2.
Correct.
Para 46. During the pre-bid meeting, all bidders requested for extension of time for tender submission. Revised time schedule for tender submission is as follows. Last date for submission existing 21-2, revised 23-2. So they, my lord, extended it. Please come down. Last 49. Kind approval is requested for para 48 of MD. Your lordship got that, my lord? Yes. Please come back to, my lord, page 520. On 2-2, if he has already, my lord, the MD had already given, my lord, 21 days approval. How, my lord, do they, my lord, ask for, my lord, extension? Please come to page 520. Last paragraph of page 520, my lord, this sheet, according to us, my lord, is the insertion. This particular page. My lords may look at page 519, last one, 41. After that, my lord, next page, my lord, if your lords look at, my lord, page 521, 42 starts. In between, my lord, there's no number. This is one aspect. More important is, please look at, my lord, page 520 bottom. Last paragraph. Considering the necessity and improvement of the importance of the project and expedite the implementation, board has on 1/2/24 has approved for calling of short-term tender. Hence, para 34 approval is approved. 2/2, my lord, he approves. Then, my lord, I ask myself, 525 on 17, where is the question of, my lord, their approval, my lord, or the MD for, my lord, the extension to 21 days? On 2/2, my lord, tender provided for 19 days. Not 21 days. And there's absolutely no answer to this.
Yes.
Therefore, my lord, my submission to your lordship says, my lord, I am acutely aware that, my lord, I have to stop. I have given the note. I have set out everything. My lord, everybody is waiting here. The whole court hall is full. Therefore, my lord, I will, my lord, the note itself, my lord, is very clear, but 3 things I want to, my lord, reiterate. One is, no reasons given, my lord, for shortening the time. My lord, section 17, my lord, specifies minimum of 30 days. My lord, please mark the word minimum. Section 7, rule 17, sorry,
17,
speaks of minimum, not, my lord, maximum.
Correct.
Therefore, it is, my lord, the rational thinking by the, my lord, the authority. My lord, who has to, my lord, give reasons, my lord, why, my lord, he is giving, my lord, only 30 days. There is absolutely no reason in the entire board note. Please look at it, except, my lord, MD's, that note, which is insertion. Even in the board note, it is not there. Board note, your lordship saw in the morning. It merely speaks of values. How much, is the timeline is not there.
The minutes of the meeting.
Absolutely, my lord.
Rule 17(3).
Yes. Therefore, my lord, look at the whole situation. Ultimately, my lord, question is this. This is, my lord, a tender, my lord, a project envisaged 10 years back. What is this unearthly hurry in a matter of, my lord, as I pointed out, on my lord 6, the order passed by the learned judge. We moved your lordships. Then my lord 3 successive holidays. Within my lord a matter of my lord half a day or even less than that, they my lord technical bid of Mega is approved, gone into, financials gone into, my lord approved. And there were 3 bidders, my lord. Everything is analyzed
Within 1 day.
my lord. I ask myself, if your lordships look at my lord, the timelines that I have given to your lordships, my lord, on the previous occasion, in respect of other projects, it runs into my lord 60 to my lord 100 to 182 days. Evaluation itself, my lord, of the bids, matter of 1 day, my lord. That's why I said arbitrariness, my lord, through and through. Therefore, we are before your lordships. Ultimately, my lord, it is this. Tender, my lord, even my lord, according to my learned friend, my lord, is interest of public. Competition, my lord, is in interest of public. Ultimately, my lord, for a project of this nature, why not invite a short-term tender which has been lingering on for the last 10 years? And my lord, for storage of power. Then, my lord, locus. Can I give your lordships, my lord, 2 judgments for my lord's consideration?
Yes.
This was lingering on since last 10 years?
Yes, my lord.
From their own
Please take, my lord, their note itself. Please come to
page 480.
483, my lord, volume 3. Yes.
More than a decade.
Whose document is this?
KPCL's report.
My lord, KPCL's reply at page 483. Note itself says that. Yes, ma'am. Para 16, my lord, at page 483. As already stated above, respondent has been contemplating the said project for more than a decade.
Contemplate.
Yes, my lord. Geotechnical investigation for the purpose of determining the feasibility of the project required.
Yes.
Then, my lord, with regard to the locus, my lord, please have a look at this judgment. That airport, R.D. Shetty, my lord. Can I persuade you, lord, to look at paragraph 9, my lord, at page 5 and my lord, 14, my lord, 1-4, that serially numbered pages the lords get at the top. Para 9.
To challenge, you need not have participated.
Yes, my
at
lord. A
all.
person, my lord, can I request you, lord, to look at serial number, line number 8, my lord. A person whose tender was rejected. My lords got that, my lord. 1, 2, 3, 4, 5, 6, 7, 8 lines from the top, my lord, at para 9. A person whose tender was rejected might very well complain that the tender of someone else was wrongly accepted, but it was submitted. How could a person who never tendered and who was at no point or no time in the field put forward such a complaint? This argument, in our opinion, is
That's what.
misconceived and cannot be sustained for a moment.
In other words, to put a challenge
Yes.
to a tender, it is not necessary that he should be a participant at
correct.
all. That way.
Then, my lord, they further say, grievance of the appellant, it may be noted, was not that his tender was rejected as a result of improper acceptance of the tender of the respondent number 4, but it was differentially treated, denied equality opportunity with the respondent number 4 in submitting a tender. His complaint was that if it was known of that non-fulfillment of the condition of eligibility would be no bar for consideration of tender, he would have also submitted a tender and completed and competitive for obtaining the contract. But he was precluded from submitting a tender, etc., etc.
Correct.
Then, my lord, please look at paragraph 10. Justice Frankfurter's, my lord, famous statement. In the, my lord, in the middle, your lord says, get that in an executive authority agency must be rigorously held to the standard which it professes in an action, etc., etc. Then, my lord, Article 14, the next paragraph, my lord, after this court has accepted the rule as valid and applicable in India of Ahluwalia versus State of Punjab, 75 Supreme Court, my lord. And in subsequent decisions given in Sukhdev versus Bhagat Ram, Matthew J. quoted above, quoted the above referred observation Justice Frankfurter with approval. It may be noted that this rule, though supportable, also as an emanation of Article 14, does not rest merely on that article. It has an independent existence apart from Article 14. It's a rule of administrative law which has been judicially evolved. Therefore, my lord, to say I am no locus because, my lord, I did not, my lord, with the greatest respect, that may not be correct. Lastly, my lord, para 12, my lord, page 17. Page 17, para 12, my lord. Because one of the argument was, oh, commercial interest, my lord, it's not so. Please see, my lord. We agree with the observation Justice Matthew J. in Punan Thomas versus State of Kerala. Government is not and should not be as free as an individual in selecting recipients for its largest. Whatever its activity, government is still the government and will be subject to restraint inherent in its position of democratic society. Democratic government cannot lay down arbitrary and capricious standards for the choice of persons with whom alone it will deal. Therefore, my lord, my submission to your lordship says this locus, non-maintainability, with the greatest respect, my lord, is not correct. Secondly, my lord, LIC, my lord, sorry.
Escorts.
Page 37, my lord. No, Allah. LIC versus, my lord, what happened was, LIC, my lord, gives, my lord, the insurance. So whether, my lord, they can select, my lord, only certain people. Para 53, my lord, if your lord says, come on, para 23 at page 53. Para 19, my lord, at page 51, the question, my lord, which was considered was page 51, para 19. Question, therefore, is whether the appellant is free to incorporate as a part of its business principle any term of its choice. Then, my lord, that is answered at para 23, page 53. Every action of the public authority or persons acting in public interest or any act that gives rise to public element should be guided by public interest. It is the exercise of public power or action hedged with public element becomes open to challenge. If it is shown that the exercise of the power is arbitrary, unjust and unfair, it should be no answer for the state and its instrumentality and public authority of person whose acts have the insignia of public element to say their action is in the field of private law and they are free to prescribe any conditions or limitation the actions of the private citizen. Simpliciter to do in the field of private law. It is action, its actions must be based on some rational and relevant principles. It must not be guided by irrational or irrelevant considerations. Every administrative decision must be hedged by reasons.
Yes.
Therefore, my lord, my submission is, and my lord, lastly, pleading, my lord, with regard to this, can I request your lord to look at page 76, my lord? Only one, my lord, thing, I'll my lord, sit down. I know, my lord, I have exceeded that 15 minutes, my lord, that your lordships have been so kind enough to give me. My lord, my apologies. Please come to, my lord, page 76. This is, my lord, 1987 Supreme 2 SEC 355. Starts at, my lord, page 68 at 76.
Page 73.
6, my lord. Yeah, it starts at 68. Please come to page 76, my lord. In fact, from the previous page, last 3 lines, what the Supreme Court has held is pleading should receive, my lord, liberal construction, all that. Now, please come to, my lord, I will not trouble your lordships. Please come to, my lord, page 76. My lords may come to second line. In such a case, it's the duty of the court to ascertain the substance of the pleadings to determine the question. It is not desirable to place undue emphasis on the form instead of substance of the pleading should be considered. Whenever the question about lack of pleading is raised, inquiry should not be so much about the form of the pleading. Instead, the court must find out whether in substance the parties knew the case and the issues upon which they went for trial. Once it is found that in spite of the deficiency in pleading, parties knew the case and they proceeded to trial on those issues by producing evidence, in that event, it should not be open to the party to raise the question of absence of pleading. That's all, my lord. I'm extremely grateful. Please pardon my... In fact, I can even, my lord, say this. Your lordships can even, my lord, appoint NTCP chairman or, my lord, Power Corporation chairman. Ask them, my lord, to give a report, my lord, within 3 days or 4 days, whether, my lord, this is. Even that, my lord, we are agreeable. Anyway, my lord, that's in your lordship's hands, my lord. I'm grateful, my lord, extremely grateful for the abundant indulgence that your lordships have shown. And, my lord, I have to seek your lordship's apologies and to, my lord, all my learned friends' apologies, my lord, for taking so much of time, my lord. Grateful, my lord.
But they just,
Read up.
your lordship asked one, just 2 minutes on the question of law that was put to me on 17.2. All this, my lord, is in my humble submission quite irrelevant, because kindly see 17.2 for a minute, and your lordship asked me if what was the position with respect to a similar position in any other state. My lord, I must say, my lord, there's some light that is thrown by a judgment of the Madras High Court which I want to place before your lordship. My lord, please see 17.2, my lord. Any
That cutting short the period.
Yes. Any reduction in time stipulated in the sub-rule 1 has to be specifically authorized by an authority superior to the tender inviting authority for reasons to be recorded in writing. This reduced time shall not be less than 7 days. Even the word shall is not used here. Now, in a situation of a similar kind, there is one judgment of the Madras High Court I want to point out. Where is the other one? One day,
Is it a parimateria provision?
my lord, appears to be so. I show it your lordship.
Again, a single judge's order. It's all right.
No, one.
No, my lord.
That's all right, my lord. Even if I give your lordships the
No,
a
they can be
judgment of
cited.
No, my lord.
all the judges of
I
the Madras
will
High
not-
Court,
not-
it is
They can be,
persuasive.
I just
they
joke,
can
my
be
lord.
cited,
I
but
absolutely.
they will not bind us.
Absolutely.
My lord, my lord is right, my lord. Even if I give your lordships a judgment rendered by all the judges of the Madras High Court, it is still persuasive. There's no difficulty about that problem. He's right. He's right. My lord, all that I'm saying is, there's one light that is thrown on the question that your lordship posed. Therefore, I'm pointing it out. Now, my lord, kindly turn to paragraph number 55 of this judgment. Well, kindly see paragraph number 48 first. The next question arises whether,
One second. It does not have a page number.
my lord, unfortunately, my lord,
48.
there are two questions that arose. One is whether after participation, a person can find fault with the tender conditions. Answer was no. Even otherwise, what would the position? I am now on the question of even otherwise.
First one is contrary to my lord, the judgment of the Supreme Court in R.D. Shetty's case.
R.D. Shetty was a little
Are
different.
totally different. R.D. Setty's case was preference was given to one person, not given to another.
Some departure of condition in granting favor, granting.
One person.
No, my lord, what I read to
In
your
that
lordship-
context, say that. you can
Yes,
sell.
exactly.
What I read to your lordship was that, my lord, whether, my lord, a person who has not tendered
Can still be before the court, and therefore the question of the locus will not arise. Is your
Yes, that, my lord, this Madras High Court, my lord, holds otherwise without even looking into that judgment. That's all I'm saying, nothing more. Locus.
Para 47.
Yes, my lord. My lord, in fact, if I may trouble your lordships, my lord, to kindly take from para 46 onwards. Oh, my lord, I'm sorry. I apologize. Part 44 onwards. I apologize. And if your lordships want to see the rule, my lord, it is there in para 41. Rule 20 of the Tamil Nadu Transparency in Tender Rules 2000 speaks about the minimum time limit for submission of tenders, and the same reads as under.
Almost identical.
Almost similar.
Or duplication.
Appears to be duplication.
Kindly see, rule 2 is verbatim almost one. Any reduction in time has to be specifically authorized by an authority superior and for reasons to be recorded in writing. Same thing, my lord. Now please see para 44. In the present case on hand, Chief Engineer has granted permission to reduce the minimum time limit of 30 days. The said proceedings were issued by the Chief Engineer on 7/5/2018. On receipt of relaxation of time from the Chief Engineer, the Superintending Engineer issued a tender notification on so and so, and the last date for submission was fixed at 18/5. That is 1 week. Thus, this court do not find any irregularity or illegality in the reduction of the time limit granted to the chief engineer. The superintending engineer also properly assigned the reasons for reduction of time limit to complete the tender and to execute the work, and the reasons are certainly genuine, and the same was accepted by the chief engineer, and orders were also issued in proceedings dated so and so. This court is of the opinion that the work is in relation to, my lord, on the facts of that case, your lordship now go
To 46.
Yes, my lord, exactly, 46.
They say directory.
Exactly, my lord. And that passage, my lord, from Maxwell, and they refer to the judgment, my lord, in SVK Sahasraram, which is very relevant, my lord, I want to point out. There's a passage from Maxwell which is quoted.
50s judgment.
My lord?
1950s judgment or?
My lord, that is a judge, no, my lord, it is a judgment, my lord, of the Honorable Madras High Court of 2008. I'll show that, my lord. Yeah, I'll come to that. But may I just point out para 46 for a minute? This apart, the Honorable Division Bench of the Madras High Court in the case of VK Sahasraman versus so and so held that the time limits prescribed in the statute are directory and can never be construed as mandatory. Such time limits as prescribed in the statute to prevent undue delay on the part of the competent authorities. However, in certain urgent circumstances or in public interest, such time limit can be waived or relinquished. However, the reasons for the waiver to be explained by the authorities concerned. Thus, the division bench held that the time limit prescribed by the Cooperative Societies Act is directory and not mandatory. The following relevant paragraphs 5, 6, 7 are extracted. Therefore, the question which falls for consideration before this court is whether the time limit which is provided under 81(4) of the said act is mandatory or not, and whether the word shall used in section 21(4) of the said act has to be construed as mandatory or not. It is well settled that the question whether an expression used in a section is mandatory or not has to be decided on various factors, and the mere expression of the word shall alone is not decisive of the matter. This question came up for consideration before the Privy Council in the celebrated case of Montreal Street Railway Company versus so-and-so, where Sir so-and-so, speaking for the Judicial Committee of the Privy Council, clarified the position at page 144 of the report as follows. The question whether provisions in a statute or directory or imperative has very frequently arisen in this country, but it has been said that no general rule can be laid down and that in every case the object of the statute must be looked at. The learned judge relied on Maxwell on interpretation of statutes, and the portion on which reliance was placed is set out here in below. Where the prescription of a statute, now this is a proposition of law, my lord, where the prescription of a statute relate to the performance of a public duty, and where the invalidation of acts done in neglect of them would work serious general inconvenience or injustice to persons who have no control over those entrusted with the duty without promoting the essential aims of the legislature, such prescriptions seem to be generally understood as mere instructions for guidance and the government of those on whom the duty is imposed, or in other words, as directory only. Where a time limit, therefore, my lord, is prescribed for performance of duty of a public authority, then it is directory. The neglect of them may be penal, indeed, but it does not affect the validity of the act done in disregard of them. That is the question. That is the precise answer to my lord's question in the forenoon. Assume, my lord, that 17(2), there, my learned friend was right, I concede, when he made in the initial submission that 17(2) has now become redundant for answer. Now let me assume, my lord, that 17(2).
Invocation.
When I say 17(2), I mean invocation. Let me assume, my lord, 17(2), invocation, no reasons are given at all. Let me assume that that paragraph is not there at all. How does it matter for the case today? If this is the principle of law so far as 17(2) is concerned.
So normal principle is that if the penal consequences are provided, then it is obligatory or mandatory. But
no, my lord, normally Maxwell said the other way.
Other
way. It is not. That's the point.
Lord,
Well,
judgments
this
of
is
Supreme
what-
Court are
one
that
minute.
if it is sorry.
One minute, if you don't mind. If you don't.
That is how I asked.
Well, yes, and unless, my lord, it makes
Neglect of them may be penal.
Yeah,
only
my lord,
but
it should be penal with invalidation. Penal with invalidation. It should be penal with invalidation. Suppose it is merely penal without invalidation. That was the question. Punish him. Punish that officer. Neglect of duty. Whatever you want to do against him. But does it invalidate the public act? Is the question that is now before your lordship. That subtle distinction between penal consequences on the one hand and invalidation consequences on the other is what, in my respectful submission, my lord, determines the grievance that has been made with respect to the non-fulfillment of 17(2). If 17(2), my lord, is directory, then, my lord, whatever they may have found fault with, it becomes irrelevant in this case. This is the judgment, my lord, that I thought I should place for your lordship's consideration. Then, my lord, I'm sorry. The aforesaid principles have been followed by the Constitution bench of the Supreme Court. In the case, now kindly see what, now the Supreme Court has followed it. The aforesaid principles have been followed by the Constitution bench of the Supreme Court in the case of State of UP versus Manbandan Lal, wherein paragraphs 10 and 11 at page 917 and 18 of the report are relevant and they are extracted hereunder. The question may be looked at from another point of view. Does the Constitution provide for the contingency as to what is to happen in the event of non-compliance with the requirements of Article 323C? It does not, either in express terms or by implication, provide that the result of such non-compliance is to invalidate the proceedings ending with the final order of the government. This aspect of the relevant provisions of Part 14 of the Constitution has a direct bearing on the question whether 320 is mandatory. The question whether a certain provisions in a statute imposing a duty on a public body or authority was mandatory or directory arose for their lordships of the Judicial Committee of the Privy Council in the case of Montreal Street, and then, my lord, the same passage is extracted. So if it is a prescription of a time limit for performance of a public duty by a public officer, the proposition, my lord, is that it is directory. Non-fulfillment, if there is a penal consequence, there is, but it does not invalidate the act. This, my lord, I respectfully submit the judgment of the Supreme Court, right, which has been followed by the single judge of Madras High Court and again by the division bench of the, and earlier by division bench of the Madras High Court, in my respectful submission, lays down the correct principle of law. Therefore, all this argument on whether 17.2, 2.2, insertion, is just an argument in prejudice. It has no bearing in law, is the submission I would make for your lordship's consideration. And my lord,
answer to it.
With your lordship's
Answer to
kindly,
it
my
is
lord, with your lordship's kindly, my lord, just one submission. In that's the reason, my lords, we made a submission before the learned single judge. All this was the point what was argued with regard to 17.2. We told him, we requested the petitioner to participate. He refused to participate, my lord. Second thing, he also raised objection saying that we need clarifications. We said, okay, we'll clarify you whatever details you want. He gave nearly 40 clarifications. We clarified that. In spite of that, the petitioner is seeking to argue legal question rather than participating in the tender, my lords. My lords, here is a clear case where the petitioner refuses to participate in the tender. He tries to negotiate with various bidders. There are three of the, out of the four, three bidders have participated except the petitioner. Even before the single judge, we requested him to participate. Now, my lords, what is now the writ appeal is argued as if it sought to be argued in the writ petition. Only 2 points were argued before the single judge. 17.2 is the main argument with the sufficiency of that period. Therefore, my lords, rest of the contention which was sought to be argued regarding insertion and all that cannot be gone into, my lords, because there are no pleadings, or that was not the ground urge that has not been considered by the learned single judge. And next, just last submission, I'm sorry, just last submission. We have submitted for the approvals, your lordship, that requested EC, environment clearance, forest clearance, as well as wildlife clearance, as early as 9th October 2023.
Please take that.
When-
In page 75 of page 75 of the.
All right, we have a memo here mentioning all those dates.
Please, my lord, I'll leave it at that, my lord. That's my.
You copy to other side also.
And it is stated in our statement of part of the tender document itself, my lords, saying that these are in the process of getting it. So therefore, the submission made by Mr. Horla, my lords, saying that it has not been disclosed is not correct, my lords. That your lordships will get it at right at the bottom, my lords. Start date is 9th October 2023. And these are the various stages, my lords, where we have applied for all the three permissions, my lords. My lord, This is the case where the petitioners is refusing to participate and is trying to pinpoint all sorts of objection why he cannot participate. And the crucial aspect is, he doesn't have E&M contractor at all. The reason why it took up the preliminary objection with regard to maintainability of the petition is, his whole seeking for time is as in he does not have a E&M contractor with him. I would appreciate if he had the E&M contractor and both were before this court saying that sufficient time has not been granted.
Take a minimum 6 months.
All right, you said that other day also, said that.
Please, I leave it at that.
My lord, we are following the strange procedure. Normal rule is, my lord, reply is by the petitioner, appellant who has started. Anyway, my lord, doesn't matter. Two things I want to place before your lordships. One is, look at, my lord, rule 17. It says minimum 30 days. I am not arguing on that. Question is, my lord, for a project of this nature, is, my lord, 30 days or even 21 days sufficient, or, my lord, larger time is to be given? If, my lord, according to them, my lord, 21 days, they must have given reasons. Why, my lord, there, if your lordship recollects, the note itself says we are calling for a short-term tender. My lord, short-term tender means, my lord, less than the time, my lord, stipulated that is required. I ask myself this question: where is, my lord, the reason given by them? Anywhere, my lord, either, my lord, in the note sheet or before your lordships. Please look at, my lord, page 495 of volume 3. They themselves in their objection statement say, my lord, that it takes 6 months for these permissions and sanctions, my lord, from the FC clearance and all that. 10 years back, my lord, this was, my lord, envisaged. Volume 3, 695. Their own objection statement. Para 40, my lord.
Page 690.
Yes, my lord. Volume 3, 695. 495, my lord. 495. It is submitted that detailed project engineering and initial survey and technological investigation would take a minimum of 6 months. Within such time, respondent expect all statutory approvals. FC clearance, my lord, forest clearance and all that, my lord, takes a long time. Your lordships are aware. So, my lord, 6 months is what, my lord, this requires. And if your lordships come to volume 1, the tender, LOA itself, my lord, is after, my lord, all these permissions. (175), my lord, page, volume 1. I ask myself this, my lord, if according to them, letter of acceptance, my lord, will become effective only after, my lord, environment clearance, FC clearance and all that, page 175. Please look at, my lord, volume 1. All this, my lord, is to be, my lord, brushed aside under the carpet? Answer is no. Volume 2, my lord, 175. Sorry. I did mention this 1.41, my lord, before above 1.42, my lord, my lord, one unnumbered paragraph. Obtaining of approvals of MOEF are in the process. In case the approval from the concerned authorities are delayed, letter of acceptance will be issued after the receipt of approval. Then para, my lord, bottom, absolute bottom. LOA will be effective on the fulfilling of the following conditions. And my learned friend says, I will now start the work. Please look at, my lord, this. Letter of acceptance will be effective on environment clearance and approval. This is, my lord, a forest. Therefore, all this, my lord, is brushed aside.
So on rule 17.
Yes.
If 90 days is given, my lord, everything is fine.
The judgment of the division.
90 days is given, everything is fine. Now all these objections will pale into insignificance.
My lord, I don't know. My learned friend, my lord, think that 90 days, my lord, for us to, my lord, going. That's why I said, look at Vidhan Saudha, my lord. They give, the Vidhan Saudha is to be constructed within, my lord, 20 days. They don't give, my lord, what is the height, weight, my lord, I mean, breadth, how many rooms are required to be done? What is the soil condition?
Rule 17, there are Karnataka.
In fact, my lord, we have kept rule 17 mandatory. We have kept, my lord, judgments, including the division bench judgment of our high court. Division bench judgment also, we have kept it.
They have kept it here.
Yes, my lord. Last time we had given it. Division bench.
It
They
says,
found out the Madras High Court single judge, my lord.
it
is
says
not.
mandatory.
Yes, my lord.
It doesn't say mandatory.
Which judgment says mandatory?
No. It says reasons.
Reasons, giving reasons is
Giving
mandatory.
Yes.
But not elaborate.
No. It doesn't say mandatory.
That, no, that judgment of Justice Arvind Kumarji,
It
which we
doesn't
have
say
seen,
if don't give
it
reasons,
does
it's
not
invalid.
discuss
No, sir.
about that at all.
Arvind Kumar is one. Second is, my lord, there is a judgment of Justice H.G. Ramesh and Justice Dinesh Kumar,
Manjunath.
joint, the division
ಇಲ್ಲ,
bench.
even that doesn't say.
Is it?
Division bench, ನಾನು ಹಿಂದೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಅದನ್ನು.
ಅದು ಒಂದ್ ಸ್ವಲ್ಪ ಹೇಳ್ಬಿಟ್ರೆ ಬರ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ.
Lord,
Citation
please come to my lord, running page.
Yeah.
In the compilation, I have given to your lordship, my lord, serial number.
Just read that paragraph very briefly.
As could be seen from the said order, the reduced time limit is not even stated in the order. Order is clearly arbitrary. Therefore, the order cannot be sustained.
No, that's another ground.
No.
It's on arbitrariness.
Arbitrary.
And of course,
mandatory.
single judge's order is, my lord,
Yes,
page,
that we
first
have
page.
seen.
Justice Manjunath, Justice
And,
Manjunath's judgment.
Prodigy.
And my lord, there is a division bench judgment of Justice Manjunath and Sujata. That, my lord, is at page 2. Oh, no, sorry, page 5 of the compilation given.
Does it hold it's mandatory? May not be.
No, none of those.
May not be.
Insofar as the second point is concerned, original records produced is verified by us. Managing director has only signed the tender notification if he is approving the same. But he has not assigned any reason to reduce the time.
That is 17.3.
Yes.
It goes to 17.
Yes.
But they've set it aside because they have.
Very well. Thank you so much.
Great.
That has to
Grateful, my lord.
read many,
So
many
read appeal number
judgments and much of
381
law.
of 2024, heard learned senior advocate Mr. Uday Holla, assisted by learned advocate Ms. So and so for the appellant, learned advocate general Mr. Shashikaran Setti, with learned, who appears? Government.
Ajay, no.
So and so for respond number 1 corporation, and learned senior advocate Mr. What is the initial? Raghavan?
KG.
KG Raghavan for respond number 2. Assisted
My
by
learned friend, my lord,
so and
is
so
from
and so.
Hyderabad, Vivek Reddy, is also a
Comma
senior
at
advocate,
length.
my lord.
Comma at length. Learned counsels for the respective parties stated that they argued the appeal finally. They further stated that the pleadings are complete and no more are required to be added or supplemented. Paragraph reserved for judgment.
Please.
Grateful to my lord.
Since the interim order public arrangement has been granted and operating till date, comma, the same shall continue to remain subject to final outcome of the appeal.
Seal number 78. Seventy-eight. Shant Kumar Nagaya.
Complaint. Warrant was issued, na?
Yes.
For appearance.
Officer is present. DDLR is present. This matter direction is to conduct Odi and Durast.
They have done it now.
Yes.
We'll dispose it. Pursuant to order dated 26/3/24. The respondent Sildar has remained personally present. The presence is recorded. Paragraph. Furthermore, learned government advocate Mr. Mahindra tenders memo dated 4/4/24, which says that
The director of
the process of undertaking coding. Who is present?
DDLR.
Pursuant to the order dated 26/3/24, the Deputy Director of Land Records, Bengal, Disposal 3, is personally present. The presence is taken note of and recorded. Paragraph. Additionally, learned government advocate Mr. Mahindra tenders memo dated 4/4/24, producing the carbon and sketch, which shows that the body is conducted and the directions of learned single judge are complied with. In that view, the contempt proceedings are closed and disposed.
28.1.
Lord, in 17.1, Lord, we have placed the records before
So
the
both
missing
are-
file committee. We
Sir,
require,
not-
it's
not
not
same.
been done. 8 weeks, Lord, time. Because since all the officials are involved in the election process.
But then the order was passed in both, is remaining present.
Same order.
Same order, Lord, but in
So
6/23 of 23, we require
With the present.
8 weeks time.
So 6/23 of 23, at the request of learned government advocate, Mr. Mahindra, stand over to 8 weeks.
8 weeks.
10th of June.
Obliged.
The presence of DDLR, same.
Same.
Respondent 3
Yes.
is recorded and noted, however, henceforth, the presence is dispensed.
Obliged.
This is Number 79. Sumo to criminal contempt.
Justice. Hello. Chief Justice, sir. Sir, Chief Justice, sir. Hi, evening. Yeah.
Yes.
It is the court illegally registered the case against me. Hello? The court illegally booked the case against me. The who are my economical livelihoods. They Krishna Dikshit also involved in illegally fraudulently. The Krishna Dikshit and ex Chief Justice not have the authority to register the case against me. I came to court for getting the justice that that respondents did attempt murder publicly manhandled me in the office. High professional I am also they are high influence. They bought them. Bought the hello. Can I proceed? Hello. Hello.
Yes, you want time?
Can I continue that?
You want time? Do you want time? Mr. Party in person.
Mr. Rao.
Hello.
Bhaskar Rao.
I'm continuing with that, but you are not response, not I not received your audio. So I am You not have the authority to continue that proceeding against me. I came to the court to get the justice. They did the attempt murder, manhandled publicly in the office, also in the public. And but your the Dharwada circuit bench and also the principal bench sold to the court to them. And you immediately you are looting my crores of economic lives. I am
Right.
living. I am living also.
Bhaskar Raudu.
Are you judges? Can I question that publicly? Are you judges? How to live in a
We'll understand your arguments after vacation.
Constitution. You not respect the Constitution. You're
Mr.
not.
Bhaskar, after vacation. After vacation. After.
Chief Justice, how to I? Okay.
Will we send out to such and such that the
Okay.
next date of the posting of the contempt petitions will be intimated by the office to the party to 13 person Uttaravali Bhaskar Rao. Sri Uttaravali Bhaskar.
19 June. Cell number 80, Mr. Jeevan Kumar BS.
I appeal for the complaints.
Yes, Madam Lord.
Passed an orders.
Definitely.
They have passed an orders with liberty to challenge that one.
Also.
Contempt.
While learned advocate, sir.
Without
Jeevan
even
Kumar
looking into.
yes, does not dispute that the order is complied with and the decision is taken. However, he says that since the decision is against the complainant, liberty may be reserved for challenging the same in the independent proceedings. Such liberty is reserved while disposing of the present contempt proceedings. However, no opinion is expressed by this court in respect of such recourse which may be taken by complainant. Much obliged.
Cell number 81.
Disposed of accordingly. So 81. applied.
81, I feel for the respondent, but we have issued him a endorsement.
Complied.
Considered and.
Rejected.
Yes. Good.
The prayer in the petition was for grant of alternative site. Learned a single judge directed it in favor of, directed that the authority shall decide the case of the petitioner and take appropriate and pass appropriate order within stipulated time. The aforesaid directions passed by learned a single judge on 66th December 22 were brought under contempt jurisdiction by filing this contempt petition. Pursuant to issuance of notice, respondent appeared and today learned advocate so and so submitted memo dated 22/4/24 in which inter alia it is stated that the decision as directed by learned single judge is taken within stipulated time and order 18/4/24 order oblique endorsement dated 18/4/24 is passed. In the aforesaid view, as the decision is taken, the contempt proceeding does not survive for further consideration. They are accordingly disposed of. It is our clarified that if the complainant is desirous to, is aggrieved by the decision, it will be permissible for the complainant to challenge the decision independently in accordance with law. In respect to which, however, this court does not express any opinion on merits.
Number 82. Still in Chidananda.
Well, I appear for the petition. Amendment petitions I have to file in the time. I have to file an application for amendment. I have served on the government. On the last date of hearing, already served.
Lord, this is covered by the judgment of this honorable court.
It is
This
not
is similar as that of serial number 15. It was posted on Friday to them, Lord. In that matter.
1 second, he claims, my lord, it is a deemed forest. Not a single document is produced to show that it is a deemed forest.
Is it, does it figure?
No, it doesn't figure at all, my lord. It doesn't figure. My learned friend show, my
That's
lord.
not correct, Lord.
Let him show document, my lord.
My submission is, the application itself is not in existence. It was rejected in the year 2019. And for having served that rejection order, I was asked to produce the acknowledgement. Today, I am producing the acknowledgement. In all these cases, the quarry lease application has been rejected.
It's not pending.
Not pending.
As of
Whether it is a
23.
deemed forest or not is not an issue now. It is not German now.
Well, let me put
Therefore,
on
it is
record my
covered by the
claims, my lord.
judgment of this honorable court. Lord, in two judgments, this
not
honorable court has held, if it is a rejected application under the amended rule 17(3)2024, it is not Lord, maintainable. It's a lapsed application.
My lord, I'll put it on my record, my application, my lord, your lordship may consider. my lord. Along
No,
with
I'm filing
serial
the-
number 15, there is no rejection till today. my lord.
No, I am producing.
I have not received so far.
No, I am producing along with the acknowledgement also for
having
having
received
served.
it.
Yes.
Along with what? Today or today?
Postal acknowledgement also for having served today.
Sent them. Said there was no order. They sent it. Therefore, they will told you how you sent it, you produce proof. Now they have produced it. Communicated. It has been communicated to you, the order.
I have not, only it is filed before this court. my lord.
No,
Postal acknowledgement is, there is a presumption
I don't
under
know, I'll
Post
just-
Offices Act 1905.
My lord, I have not, I have to cross check that, my lord, whether it is sent.
It is there.
It is covered by this order.
My lord, it is not, my lord, respectful submission, my lord, I submit, my lord. Let me, then I'll, permit me to file these applications before lordship. Let that be on record, my lord, for the. That there may allegation that I have not challenged that, my lord. Let that be challenged before this court, my lord, lordship may decide whether rejection of the application, even after the orders of this honorable court in earlier writ petition, is legally permissible. Your lordships will kindly see in that, my lord, what it says is, the deputy commissioner proposes to send this land for deemed forest. That's no concept of the, now if at all land has to be made a forest land, it has to be made under the Karnataka Forest Act.
Earlier you filed your objection.
Yes, my lord. Today I am not objection, I am
Objection,
producing. It
let
is
him file objection.
Is there any objections are filed?
No objections.
no
are filed.
objections are filed since it is covered by the.
Simply it is.
I am producing all the judgments, even in the connected matter. In serial number 15 also, I am producing postal acknowledgement, rejection order, as well as two judgment of this honorable.
It is covered against.
That is not, with all due respect, my lord, I'll
Still-
submit, my lord.
Still you are smiling.
My lord, let me then, my lord, file, my lord, these applications, my lord, for the, on record, my lord, whether it is.
Since you are smiling after vacation.
Please. Including serial number 15, my lord.
Including serial.
30th June, 30th May.
Please.
The number 83.
This is to be heard, my lord. I have no objection. I'm ready. This is to be heard. I have no objection. I can.
Is it the same matter? No.
Now, my lord, matter relates to
Different matter.
withdrawal of OTS.
OTS,
Had heard?
Yes.
according to us, OTS, we have paid the money. Thereafter, they have withdrawn is our case.
After vacation.
We heard in cooler climes.
4th June.
The interim order may have to be continued.
Number 84.
Paying for the petitioner, my lord.
Madhukar and
sought-
Deshpande.
I have sought for review of the order, my lord. Petitioner was a student. She sought for a permission to appear for the examination for the second phase, second year, third year, and subsequent year, my lord. And she was.
Service
permitted to-
awaited, na?
Yes.
R3 is awaited.
The date, my lord, if after vacation.
19th June.
Seal number 3. Last number SB.
As per the company, Lordship, I kindly take out the orders of annexure A, my lord. Order of annexure A, the speaking order is runs from page number 10, my lord. Page number.
After vacation.
Date may be fixed, my lord.
Date will be given.
Yes. Against the interim order and.
Against interim order. No, there are 2, 3 matters. Please.
After vacation. Seal number 4.
The complaint.
Go to 10.
Pardon?
After vacation.
But notice maybe should, because I am debarred from participating in the tenders, my lord, it expired the interim order.
Interim order.
Yes, interim order granted by this honorable court, my lord, I was debarred, I mean, the debarment order was stayed. Despite which, my lord, the 7 tenders.
Main matter is pending.
No, that is also disposed of, but liberty is granted to me to challenge that violation of the interim order, my lord. That is why before my lord.
Main petition is disposed.
Dismissed.
No, it is, no, they conceded before the learned single judge saying that, my lord, they did not issue a show cause notice to me, but before passing a debarment order.
Notice all right, notice written. 5th of June.
Seal number 5. JC Prakash.
My lord, in respect of my lord, respondent.
What's the urgency? Only 4 days we were working. Only urgent matters you have to mention because many urgent matters people are waiting.
My lord, on last occasion, my lord, your lordship
Appeal,
directed to accept notice in respect of R1 only.
The direction is to acquire land for him.
Notice
10,000.
not ordered in respect of my lord, R1 to R4, my lord.
10,000 square.
10,000. You want to acquire?
Acquire for sale.
We are contemplating to file appeal is my.
That's what.
My lord, last occasion, my lord, lordship
after
directed to accept notice R1.
There are many urgent matters. So you should understand
Please,
the
my lord,
difficulty of.
I accept
All right, call up
notice.
vacation.
Notice
Okay.
not been ordered in respect of
All right.
R1 to R2 to R4, my lord.
Let us see.
Kindly notice.
Can there be a direction to acquire the land? Yes.
Number 6. Mr. Swami NBN.
My lord, my only respectful.
You have said that. Leave.
Notice may
Yield
be
place to
ordered in
others.
respect of R2 to
There is no
R4, my
urgency.
lord.
There is no urgency.
Yield
We'll deal
place
with
to
it.
others.
Number 6. Mr. Swami NBN.
Complaint. Question of filling of a backlog vacancies.
Filling of
Backlog.
this can go after it.
At least notice can be ordered. Notice can be ordered.
Notice
Okay. Date
I accept for our.
10th June.
10 June. Much.
Number 7. Mr. KK Vasant.
This is that's the retirement age.
58 to 60.
But there is quite of all fast, no steps are taken, notes have been issued.
So
And notice may be issued to all the.
this is the same matter pending before the Supreme. Virus is still. Somebody was mentioning.
This is different.
These are only the enhancement of.
This is in case of
age
Mysore.
from 58 to 60 years. That is ordered on 28/11/2023. And notice also issued on 6/12/2023. In spite of it, they are not considered so far.
Respondents are directed to enhance the age of superannuation.
Yes.
My lord, I appear for respond number 3, 4.
But they are actually, both are actually very sick. Notice may be ordered.
After vacation.
Well, notice may be ordered so far, in both the cases. Notice to the accused.
All right, notice written. Notice written. 11th June.
11th.
But you can yourself enhance your age instead of learn a single judge.
No, what has happened, mother, they're both are sick. Both are sick. For that reason.
All we are noticing.
11/6, mother.
Other matter is also the same.
I pay the process.
8 also said. 8.
And 8 also same.
Number 9.
Yes.
Mr. Sunil Kumar H.
Contempt is filed with regard to the non-compliance of learned single judge order. It is communicated to them.
Ex
everything
parte,
they know.
interim, both.
Lord, the learned single judge has detailedly heard me. And
Is it the interim order?
Interim order, my lord, and he has stated And we have communicated to them, my lord, they were not even challenged it. Only respect, a notice may be issued, my lord, because no respect for learned single judge order.
Therefore, you should tell the learned single judge that your respect is breached.
Please, my lord,
He will
learned
take
single
action.
judge, my lord, we have mentioned to him, learned single judge said it amounts to contempt also.
You should take it.
That is why we have initiated contempt, my lord. Lord, tomorrow, my lord, every authority,
In
they have no
every-
respect to any orders.
We have already taken the view, it is affirmed by the Supreme Court. In interim orders, it is not that we don't have jurisdiction, we have, but we decline to exercise. Because matter is pending, you can complain to the judge himself that your respect is breached. He will take action.
Only request notice, because.
The heard learned counsel, Mr. So and so for the complainant. It is evident from the order brought under contempt jurisdiction dated, order dated 14th March 24, passed by learned single judge. Brought under the contempt jurisdiction of this court is an interim order. By very nature of the order, the final rights of any of the parties are not crystallized. Not only that, the dispute is at large before a single judge on its merits. In that view, the court is not inclined to entertain the contempt, exercise the contempt jurisdiction, leaving the complainant at liberty to approach the on a single judge to work out his rights and rights in the proceedings pending.
Please.
Same
Number
court.
10,
The pending proceedings.
Srinivas Gowda.
Complaint, annexure A is the order passed by the single judge. That let's page number 30, column last. In terms of this blood, that the authorities are.
Survey, some surveys to be raised.
Survey,
18th, 19th June, notice.
notice.
19 June.
Notice.
I accept for R1.
R1,
R1.
it's in personal capacity. Personal capacity. R1 is-
Performa.
R1 to 1 and 3, my lord.
R1
And
is,
three.
R1 is.
One you are appealing.
3 Tahsildar, my lord.
Mahindra except for RN, R1 and R3,
R1 only.
only R1.
Rest of the thing notice.
It's education matters. Number 11.
Not in this
Padavi
matter.
Raman.
I request
For the
for a
petitioners.
short accommodation since my colleague is appearing.
This is regarding fee.
My lords, it
Yes.
is regarding
It will
admission.
not come here.
No, my lords, may I request my lords, because urgency is the
No,
admission.
No,
Whether
it goes to the roster bench. No?
No, my lords, it's not a fee structure, my lords.
Fee structure.
It is admission matter, medical admission, therefore my lords office. is
No, no,
not
it is with regard to fee only. They are claiming blood as per the letter written by the Director of Medical Education.
My lords,
That
I may be permitted to make submission.
the
my lords,
fee
so
has
that
to be
It is not
charged
a-
at.
My lords, I'm sorry. It is not fee structure, my lords, it is notified fee to the students. What has happened in this matter is, all these students, 150 students were relocated pursuant to the order of the NMC, my lords, and also which was affirmed by this honorable court in this, in the writ petition. And thereafter, counseling was also held, my lords, and
But
all.
it is, you read your prayer, it is fee, not admission.
No, no, my lords, kindly see, my lords. That is fee.
Your
noti-
prayer.
Yes, yes, my lords. The
First
fee,
prayer.
first, that to hold and declare that the fee paid by the petitioners for the management quota as received by the sixth respondent college at the time of admission for the academic year 22-23 is a fee that was notified to the students at the time of admission to the sixth respondent college for the academic year. And next, my lords, to hold and declare that the management quota shall be as stated by the DME in point number 2 of the letter dated 2/2 as per annexure J. Here it is, my lords, fees, not fee structure. The fee which was already given by these students to the sixth respondent college at the time of admission for the academic
We'll
year.
ask the registrar to examine. Registry shall re-examine the placement of
My lords,
this.
my lords, may I request this? In the event, my lords, now only 7 students are now stuck. And they are not allowed to attend the classes also.
If this bench is not able to take up, not able to take.
No, my lords, it is not the, my lords, my request is.
So we'll ask the registry again to examine whether.
No, my lords, it is not examination, it is attending the classes of exams.
No, no, we are directing the registry to classify, re-examination, the classification. We are of the view, this is a matter pertaining to fee, not admission.
My lords, a
Essential.
stoppage of admission now, it is not, my lords, the fee structure is between the government and the private medical colleges. The dispute is that. It is not the fee which is not structure which is in dispute.
Having regard to the nature of the prayer made, The registration, re-examine the placement of this appeal
My lords, in view of
to
urgency,
place
my
it
lords,
before the approved bench in accordance with the roster.
my lords,
Obliged.
it may be, my lords, it may be, at least my lords, it may be placed before that court tomorrow, my lords. Because
Either we are right
only,
nor you are right. Registry will say.
no, my lords, it is, my urgency is not the, my lords, the
Order.
students are not attending the classes. The students are not allowed to get into the classes, my lord.
It will be listed, place it today itself.
Fee structure.
Fee structure, no, it will fall in place. Anyway, same.
Reclassification. Cell number 12, the PL matters. Mr. Madhusudan Adiga B.
I appear for the petitions, my lord. Matter pertains to the misrepresentation and obtaining of two sites by the same family. Two sites in
This is PI. This resolution is not. Some resolution you are challenging. Resolution of the municipality you are challenging.
I'm not challenging the resolution of the municipality has to pass a resolution stating that it will not be used for any other purpose. That has to be implemented.
Resolution favors petitioners, they have to take up.
And two sites have been obtained by the mother one side, son another side. Misrepresentation. And after 14 years.
Notice.
4, my lord.
1, 2, 3, 4.
Yes.
2, 4.
Notice to others.
Obliged.
26, 6. Cell number 13, HR Tori.
It's a writ petition filed in the form of public interest litigation, my lords, wherein, my lords, a water body, my lords, which is also a Kalyani, my lords. In the sense, it has been, my lords, used by the.
What is Kalyani well?
It's a well, it's a holy well, we can say, my lords. That part, almost 1 acre, 26 guntas, my lords, on a representation given by one community for reserving this land for the purpose of burial ground, my lords. Despite there being several burial grounds within the short distance, my lord, this where several temples are there, this water. And my lords, there is a threat.
Respondents submitted to the aspect
1, 2, 3, 4.
as to whether the place where the crematorium is proposed.
No, it's not a crematorium. It's a burial ground.
Burial ground.
Burial.
Is a water body.
Reservoir.
Yes,
In a rest.
it is.
Will inform
Lordship, may kindly see
on the next
the
page.
report.
Lord,
the
I'll
only-
take instructions.
2, 3, 4.
1, 2, 3, I'll take notice, my lord.
1, 2, 3.
May I seek a short indulgence, my lords, because it may be if they use it, my lords, for as burial ground by then, my lords, that protection may be given. Otherwise, my lords, it would lose its sanctity.
Interim relief is refused.
27, 6.
Write down interim relief is refused.
Cell number 14, Mr. Doraraj BH.
Here for the petitioner. You want that to write down, mister? You want that you to go black and white, that interim relief is refused?
No,
Contract.
14,
I appear for the petitioner, my lord, in this matter. This is the Karnataka Medical Council. Elections were held in January 2020, my lord. Nominations were made under section 32C illegally by a public interest litigation filed by the petitioner itself.
Who are you? Busybody.
My lord?
Who are you? Busybody.
No, my lord.
What are your credentials?
My lord, my contention is, my lord.
Credentials, who are you?
I'm a
What's your
doctor, my
standing?
lord. I'm also a doctor, my lord.
Doctor. What you have to do with this legal legislation? Since how long that nominated, they are not nominated?
My lord, 20 January 2021, my lord, illegally it
Notice.
is going on.
Notice returnable on 12th, 13th June.
My lord,
Much
I
obliged.
take notice for respondent number 1.
Honored additional government advocate, so and so, so and so. Accept notice for number 1.
Much obliged.
15 adjourned. December 16. So green bench matter, Sri Sharavan Madhav, KP.
For the petitioners.
This is it. Environmental compensation.
Environmental compensation.
So when all matters are
Similar matters are pending.
Pending.
notice, formal notice.
Recovery notice.
CH-1.
Your Lordship, consider
Please
the
don't-
interim prayer.
AGA for 1, 2, and 3. So 1, 1, 1, 1, AGA 1.
AGA for 1. 26-6.
Interim. prayer.
They have said that they will not precipitate in the other group.
Another groups you have said that.
You got the number to be
Do you
listed.
have the number? Yes.
Hello.
WP 2573 of 2023. Number 17. Aniruddhanand.
I appear for the petitioner in this case. Lord, as per Annexure D, there was a request made by PCCF to the State Forest Secretary. Brief facts are like this. I had a mining lease from 1954, 2 leases, my lord, are carrying on. And then, my lord, what happened was in 2013, my lease came to be renewed. Lord, in 2007, FC clearance was given to me. But as per Annexure D, the PCCF writes to the State Secretary, if your lordship would kindly see the date, 6th of January 2014.
Your
My
lease
lord
ex-
gets it at 139.
Lease expired when?
But lease was extended.
33,
but
my lord.
2033.
2030.
Yes, my lord. And I had the protection of interim order from 2014 by the Apex Court till recently, till March. Then the Apex Court said, you go to the respective high courts. Kindly see, my lord, the interim order granted earlier at Annexure G and G1, my lord.
Page number?
Page number, my lord, Annexure D is at 151. And if your lordship would kindly see, yes, 152, my lord, at the bottom. Item number 301, my lord gets it. On the left-hand side.
Yes.
We have heard the learned counsel for the applicant, learned senior counsel appearing for the Ministry of Environment and Forest, who prays for time to file a short reply. 2 weeks' time is granted for filing a reply. In the meantime, the communication dated 29 January of 2014, that is challenged here in Annexure A, of Ministry of Environment and Forest to the effect that the applicant, the Sandur Manganese and Iron Ore Limited, shall stop all mining operation, shall remain stayed. Kindly see the next, my lord. This is the order made, my lord, on 24th of February 2004. 10th of February, my lord. Thereafter, if your lordship would kindly see at page 154, Annexure G1, at a relevant paragraph at 156. My lord gets it at the top of 156. IA number 208 in the writ petition so and so, that is my writ petition, IA. The Ministry of Environment and Forest has not filed a reply. 2 weeks' time is granted as a last chance to file the reply. Interim order will continue in the meanwhile. That they continued, my lord. Now, as per Annexure P, at page 213, at 229.
You are relegated to the High Court now? High Court.
Yes, my lord, I am relegated to the High Court. Interim order is there from 2014.
Throughout he has interim order.
Yes.
And state government is in my favor. It's only the central government which has done this.
They have
But
the
you
benefit
did
of
not.
interim order for.
Your
Lord
last
Supreme
may
Court has
kindly have it
extended.
after vacation, not till.
No, what is challenge? What they have challenged now?
Now annexure A, my
Not
lord,
FC,
what was
forest
challenged?
clearance, not.
Yes, lease till 2033.
All other clearances are valid or expired?
It, my lord,
All other
clearance was,
clearance are valid. Lord, so far as forest clearance is concerned, there is an issue. Lord, therefore, this particular letter produced at annexure A is.
Supreme Court.
Supreme Court itself has protected all through.
on the
All
other
through, he
hand,
has been protected
He
by
has,
the apex court.
he had.
You are in the
Yes, yes.
under
My-
contempt of the Supreme Court.
and secondly, my lord,
Your officers are under contempt of the Supreme Court.
No, no.
Yes,
Sir.
There was interim order
Lord,
throughout
sir,
before the apex court in his favor.
Interim
Yes.
order was
And they
against.
relegated to the high court because generally they should be treated by high court benches.
yes, my lord.
Now what happened, my lords? While relegating them to the High Court, my lords, the interim order came to be extended for a further period of 2 months, which will be valid till, my lords, 13th May 2024.
Yes, my lord.
But it will expire during the vacation.
During the
it will be-
vacation.
Therefore, he
is-
has to be
That
protected.
is
My lords, may I
exactly for
request
the
one
reason
thing,
I
my
made a submission. Your last may kindly have it after vacation. But till then, the interim arrangement may be extended. We will file our.
Even, my lords,
Lord.
may I request my lords to turn to page 176
Or
for a
learned
moment.
senior
my lords.
advocate, Mr. D.L.N. Rao, assisted by learned advocate so and so, learned government advocate, Mr. Mahendra, for the petitioner, then learned government advocate, Mr. Mahendra, for respondent state and learned senior advocate, Mr.
Central Government, Union of India, my lords, R1.
Union of India. First respondent, then Mahendra, in that order. Notice returnable on.
Even the particular issue is, my lords, clarified by us.
Which was never asked to them.
May-
State is in my favor.
My lords,
I'm sorry, my lord. My apologies.
may I request my lords to turn to page 176.
Anyway,
Yes.
till second week of May, apex court has protected
Yes,
him.
No,
And
I'm in
27th, we shall be.
I'm in
reopened.
their
They
favor, my lords, I'm pointing out
want
that.
to favor him.
Yes, yes.
Page 176 may kindly. Page
They themselves
176,
are-
Learned
we have
senior
clarified
advocate-
that, my lords,
learned senior advocate could demonstrate from the record that the Honorable Supreme Court has granted interim order in favor of the
176
petitioner,
para
which is
three.
in operation. In
Yes.
that view, the same order shall continue till the returnable date. Returnable will be 19th, 20th June.
yes,
May I make one request, my lord? May I make one request? This ad interim order, it can be stated because Supreme Court protected and never limited the interim order.
The same order we have
Same
given
order.
now.
Very
Same
well.
order.
Same.
Whatever is granted by Supreme Court, we are granting.
Obliged.
Supreme Court, as my lord said, it will be continued for a further period of
To
2
enable
months.
him to
We have-
approach the High Court.
Yes,
We have elongated it.
lords, in fact, my lords, my respectful submission is, lords, pursuant to the.
Let us see after, let it come. Yes.
Yes.
No,
File
it is
objection.
clarified, my lords, that's what I want to point out.
What clarify?
That, my lords, the certificate, what they are contending, that, my lords, now it is only for a limited period. We have clarified, my lords, it should be in
Road.
co-terminus with, my lords, the
the
mining
mining
lease.
lease.
So of 2033 on that, with if all you agree, we can dispose of the petition itself with that observation.
Yes,
Yes, that's what, my lords.
Mr. Mahendra.
I'll seek instructions.
Mahendra is in my favor, my lord. See annexure E, Mahendra state government says you allow them to continue. Annexure E.
Little early, 10th of June, 10th of June.
We have said that it should be co-terminus with, my lords, the mining lease.
Let us see what
His,
it is.
may I humbly request the statement of the learned council for
Your own document. I am
central
saying.
government may be.
No, they have written it.
Yes, I know, 2 documents I have
Have
produced.
said in your favor.
Very well.
Yes.
Writ appeal matters,
That-
case number 18.
I thought it could be
Appeal
disposed of on their
That is what
statement.
we suggested, but.
Mahendra
learned-
wants to file
Mahendra,
objection.
my lord, I'll take 1 minute, my lord. Kindly see annexure E, my lord.
Allowed. In
Just
fact,
for a minute.
If it is in the part of the, if it is part of record, then she'll enter a ground.
Annexure E. Case,
Yes, to file.
annexure E state itself says allow them to work. And
We'll have
Mahendra,
his version, we'll have the version of the state because we don't want to lay down any possible precedents.
but only one small thing is, Mr. Mahendra has the habit of opposing everything, even though it is, my lord, in my
No,
favor.
no, otherwise I
and
wouldn't
they
wouldn't
admit-
have considered for extension of interim order till
Your
After,
concession
till
is
after
not
vacation,
required.
till
Supreme
filing of
Court has
statement
given
of
that.
objection.
Order
Not
came to be,
objected our entry.
my lords, order came to be passed in the year 2014.
Leave others.
We have
He is,
clarified.
Mahendra is justified. He is
Yes.
protecting the interest of the state.
Yes.
Yes.
Number 18.
My lord, I appear for the appellant, my lord. My lord, the order of the learned single judge directing the government to conduct a survey and durast in respect of 2 acres of land. My lord, I am aggrieved by that order, my lord, and I have filed this appeal. Since the land is government B Kharab.
The government be corrupt.
My lord, it comes within 18 kilometers from the city of Bangalore. There is a delay of 190 days, my lord, in filing the.
Learned traditional government advocate. Yes. Nilofer Akhtar for the appellant. State. Notice to the respondents returnable on 27th June. In the facts of the case, the judgment and order delayed. Then little earlier, if delay is there, 13th June.
Obliged.
Number 19. Nilesh Krishna.
My lord, it's an education matter. My writ petition is for refund of entire course fee, my lord, which was forcefully collected by the respondent college for returning of documents before I take the counseling in Uttar Pradesh, my lord. My lord, the learned single judge.
Notice.
Yes, my lord.
11th June.
Yes. Number 20. Badri Vishal.
Lord, I appear for the state. My lord, my lord, this is against an interim order that is passed, my lord.
That's essentially we have challenged an interim order whereby the respondent number 1, we've been directed to keep the respondent number 1 as a professor in the first appellant university who is over the age of 60. My lords, a full bench has been formed to consider whether the age of superannuation is 60 or 65. That, my lord, I believe is posted on the 16th of June. This matter will be posted after that.
Identical matter.
It's not identical, my lords, but the question as to whether, as per the AICTE rules, the age of superannuation is 60 or 65 is considered. So this matter may be
60 or 62?
65.
65.
I believe so, yes.
So this is in your favor? Who you are for?
My apologies.
You are for applying.
But it's against the interim order.
I have challenged an interim order, yes, please.
Any interim order is granted there by the larger bench? No, not granted.
I don't believe so.
No interim order is granted. 14 June.
So he is continued to be permitted on service till 60 years.
Now he is 60 years old.
He is over 60 years old.
He's
He's been permitted to, rather we have been directed to retain him as a professor despite him being over 60 years old.
So he is permitted to continue in the beyond the 58 years.
Yes, please.
My lord, he retired on 31st August 2023.
Already retired.
Yes.
But then he is functioning today.
No, he seeks to continue.
But by virtue of order, he is in service.
Are you still functioning?
Yes.
No. You are functioning?
Yes, please.
As professor?
Rather, no, my lords. I am the university.
Your college?
My college. The respondent number 1 is continuing as a professor in our university.
In your college?
Yes, please.
What is done by the full bench, Miss Nilofer?
My lord, it's adjourned, my lord. It was heard in part, it's adjourned.
But interim relief is granted. Then after vacation immediately.
Please.
29th of May.
whether against our judgment matter went to Supreme Court.
My lords,
No, it has got to full bench because of conflict. Conflicting decisions. Matter is before.
Clear keeping and reopening. Notice returnable on
My lord, I take notice for respondent number 2.
3rd of June.
My lord, 2 and 5.
2 and 5 you appear.
Yes, sir.
2, 5, 6.
And director also, my lord.
So number 21,
3,
6.
6, 1, 2 and 6.
My lord, no, 2, 5 and 6.
so number 21, Mr. Chandrakant R. Patel.
I appear for the appellant's counsel. A site was allotted to the petitioner appellant, and possession was delivered on 23/5/1969. It is sought to be resumed. In the meanwhile, there was some negotiation. I even wrote a letter that half the site may be allotted to the petitioner, though entire site is in my possession. To execute the sale deed is sought to be refused. One of the ground made out is we have refunded the amount you paid by a check. I have got it verified from the society. This check has not reached the society, nor is it encashed.
That is 8,83,000.
Yeah, not 8 lakh, my lord, it's 8,083 point.
1,083.
notice 14th June.
Please. My learned friend may take notice for 1, 2 and 4, my lord.
I take notice, my lord.
1, 2 and 4.
1, 2 and
2
4.
and 4. So number 22. Parani.
I'm affected the appellant, my lord. Appellant is working in second respondent institution, my lord, since 2006 to till today she is working, my lord. Provisional list, my lord, has been selected in 2014. My
Notice.
my lord, till today she is working, my lord.
But there is
them
delay,
not
more
to
than a
terminate.
year.
She is still
Delay is
working.
there.
Delay of 448 days. Notice returnable on 20th June.
My lord, I take notice for
R1.
respondent number 1.
Number 23.
Appearing
Hearing
for
on
respondent
applications,
number
number
2.
23.
My lords, I'm appearing for the Bangalore Development Authority. Only one office objection remains, that is production of legible copies of the sketches. The submission is reproduced the records as it were from the writ petition. So, my lords, may be pleased to accept my submission and overrule the office objection.
If I may make a submission, Your Lordship. The appeal was filed on June 2022 and the office objection has not been complied since then. And the matter has been recalled twice, Your Lordship.
All the office objections have been complied. Only one remains, that is all the other office objections have been complied, my lord. Only one office objection remains. That my submission is that legible copies are not in my.
We'll see after.
My lord, sorry.
Date may be fixed. Date 6th June. 6th June.
6th June. This is seal number 24. To P. Chinnappa.
Hearing for the complainant, my lords, application filed seeking to revive the contempt proceedings, my lords. This honorable court had granted the accused a period of 10 weeks from 12th of October 2023 to reinstate me into services and pay back wages, my lords, in compliance with the single judge's order while dismissing their writ appeal, my lords. Till present date, I've neither been reinstated nor have back wages
Notice
been
is
paid.
notice returnable on
19th June.
Much obliged.
19th June. Notice on application. Number 25.
Session number 25. And on the last date of hearing, I had undertaken to place before this lordship the scheme placed before both the houses of Parliament and Legislature,
So with-
modification of the pension scheme.
along with appeal. Appeal is of which year?
Two petitions, sir.
12. What is it? After vacation.
I seek lordship's indulgence to grant some time. I will place those materials on record.
6th of June.
Obliged.
Next week, my lord, after 6.
After
13th.
13, obliged.
13th June.
My lord, in serial number 25.1, my lord, we have filed wakalat on 4/4, but it's not, but the name is not showing for R2 and R3.
Registry will kelbeku. You have to inquire in the registry why it has happened.
Okay.
Number 26. P.V. Chandrasekhar.
Petitioner's counsel. There is an application to place the money in deposit in a fixed deposit note. We deposited 20 lakhs pursuant to interim order. And there's also an application for continuation of delay. IA 1 of 24 is for a direction. Filed by the respondent, we have no objection to that. Delay of what day?
Delay how many days?
61 days. 61 days.
Filing.
No objections are filed. Allowed. Delay. I think IA3 does not survive, not this noting.
IA3 does not
IA3
survive.
does not survive. So IA3 will not survive accordingly disposed. And IA1 for deposit. 61 days delay. To put it in a FD, my lord, for some interest.
He has already budgeted the fee. We should registry to be directed to put it in.
In a fixed deposit.
In terms of IA.
No.
That was 20 lakhs.
20 lakhs.
Not 24. You have deposited in the registry.
Yes, my lord. Good. 30. So this is pursuant to some order of the case, order of this honorable court of 28th of March. Pursuant to order of this court dated 28 March. 28 March. 2024, comma. 23, my lord, 23. The petitioner appellant has deposited amount of rupees 20 lakhs with the registry of this court. The registry is directed to invest the state deposited amount in a fixed deposit with a nationalized bank. Cumulative deposit with a nationalized bank, initially for a period of 3 months. 1 year.
1 year.
1 year. Yes, we'll finish it next time itself. Which shall be renewable. The fixed deposit receipt shall remain with the registry of the court in the custody of the registry. Main matter will go when? June 21st, June 21st. Good.
Yeah, 24. December 27.
Lordship, in this
P.A.
matter,
Kadambaya, non-filing in
my
form.
lord, Lordship, I have filed the wakalat for accused number 2 in this matter. My name is not showing. Registry may be directed to show my name, Lordship. Accused number 2.
You appear for accused.
Accused number 2, Lordship.
2, Sushilamma.
Yes, Lordship.
I appear for the complainant, my lord. The acquisition is of the year 1981. The order is a consensual order, my lord. Accused has agreed to pay 1.44 crores, which is 4 times the market value, for using 38 guntas of land of the complainant without completing the acquisition proceedings. My lord, kindly look at the order on page 44. The petitioners is more than justified in insisting that the government should get the sale deed from his clients within a period of 3 months by making the payment as been assured in terms of Deputy Commissioner's letter, failing which the petitioners would be entitled to interest at the rate of 18% on the amount of assured. My lord, it's been over 10 months. It has not been paid.
Restoration is your role.
Kindly grant me 6 weeks, Lord, by that time.
The request of learned advocates for the respondents. And we'll keep immediately. On 3rd of June.
10th of June, and because immediately after election.
10th of June. 10th of June. It is expected that the orders will be complied with by the next date. Name of learned advocate Miss so and so shall be indicated as appearing for this one for so and so while notifying the petition on the next date.
Number 28. Pratik Chandramouli.
And that's for the accused, for the appellant in the appeal, my lords. Appeal is also pending, my lords. Contempt and appeal both are pending. I would only request, my lord, there's one more identical appeal that may be taken along, my lords, with this matter.
Connected matter.
Please, my lord, there's one more.
Number you have to give.
Please, I'll.
So to be noticed to be listed with
15, please.
number, whatever number. 124th of June.
Please.
Number 29. Sharat Kumar Shetty.
Appearing for appellant, my lord.
In this matter, we have complied the order, Lord. I'll file the complaints affidavit. Your last may kindly have it next week. Order has been complied.
3rd June. You know, extend order to 3rd June in order to enable learned government advocate to produce the compliance, order.
Number 30.
30 also, Lord, we have complied and RTC is there, Lord.
You have restored names in the RTC now.
Yes, yes.
You can drop the proceedings on that assurance.
Yes, okay, man.
The parties through their respective learned advocates are addendum that the direction is complied with and the name is inserted. Name of the petitioner is inserted in the revenue record. The contempt proceedings are dropped and disposed of.
So 31 adjourned. Number 32. Mr. Anumanta Parvigowda.
Lords, I appear for that matter. It's been complied. I have the compliance affidavit. It's in Kannada. Lords. I'll file I didn't realize. I'll file a translated copy. It's been complied on 9/5 only.
Complied with
already complied.
Complied. I just passed
Need to file translate.
That's what.
Complaint.
If not complied with, then yes.
My lords, but even then, my lords, it's our duty. He didn't realize, my lords.
You have complied with that.
Complaint. I've not served a copy on my friend, my lords.
Compliance affidavit dated. Which date? Dated
Saturday's date.
22/4/24 produced today. Contains copy of the endorsement of the order dated 24/4/23.
It's served on my friend.
Dated to the
Sixth,
complainant.
it's space number 6. My lords,
Accordingly,
served on
the
9.
directions of learner singles are complied with. The proceedings are dropped. So it is against them.
I'm sorry, ma'am.
Against them, order is against them.
Against them.
Also, liberty is reserved for the complainant to challenge the endorsement of the order in independent proceedings. If so, advised. This court, however, does not express any opinion on merits on such recourse. Full stop.
Number 33.
This is petition converted as a PL, my lord.
Hearing for
Thereafter,
respondents,
I
one-
complained the office objection on 1/4/2014, so 24, my lord. On the evening it is called and the PL converted to petition has to be separated. Hence it was separated and the pagination made on the that Saturday, my lord. That on that reason that office objection is noted in the cast title, as list, my lord.
It's a Gamtana property.
Yes, my lord. Detailed hearing required, my lord. Without passing up any title, they have passed a resolution to change the kata in the name of the respondent, 10, my lord. That office not to be removed in the car.
24.
Please, madam. Oblige, madam. Number 34.
Your Lordship, I appear for the petitioner. Your Lordship, this writ petition has been filed for the failure of respondents to comply with their statutory duties in ensuring an equitable supply of clean drinking water. Your Lordship, the matter is of great public importance to the ongoing acute water crisis. Your Lordship, on the last date of hearing, the respondents were directed to furnish public reports. The same has not been furnished. My lords, may kindly have a date fixed for hearing and also direct the respondents to furnish the reports.
I have filed on 4th October 2023, my lord.
You have filed the objections.
Yes.
Where is your objection? Page?
My lord, I have filed an affidavit giving details, my lord.
Affidavit by one P. Nagaraja.
Yes, PN now.
17 July.
So after vacation will come.
After vacation.
19th.
Like,
Number 35. Mr.
Please.
Manaprabhakar Kulkarni.
Please, my lord, for the petitioner. But on the last 6 occasions, they have sought for time. But this is a petition challenging, my lord, the validity, constitutional validity of a statute which is directly contradictory, my lords.
Apex court decision.
Please, my lords, as well as this honorable court's decision. 6 states, my lords, they have sought for
my
time.
lord, finally, some time may be granted, my lord.
This court. Which is the division bench judgment of our High Court?
Lord, in the PIL, my lords, that was pending. Lordship, may kindly see, my lords, the order sheet starts at page 84. Annexure F.
This is a long matter.
Yes.
Please.
Virus is challenged. 25th of June.
25 June. Say number 36. Mr. Nitin Ramesh.
Lord, I appear in this matter, my lords, it's a PIL. A detailed order was passed by this honorable court on 14/12/2023, my lords, acknowledging the public importance raised in this petition regarding wearing of child safety helmets in terms of Central Motor Vehicles Rules Amendment, my lords, which has already come into force, but which has not been complied by the state at all. The state was expected to file a response by this honorable court, but till date, they have not come forth, my lords.
File response.
I'll file.
Lords, as a last chance, please.
Before the next date, the response shall be filed by the state authorities.
You have filed it already?
No, my lord.
Not filed.
My lord, the problem is with regard to the
10 or 2.
manufacturers, my lord.
That's a state duty.
18th of June.
Number 37. Mr. S.Y. Shivali.
Nobody is there. 28th June.
Number 38. Ravindra Gajanan Kolle.
Yes, ma'am. Please,
No urgency.
Yes, my lord.
Oh,
And
28 June.
identical matter is pending and listed on 30th May, my lords.
28 June.
28 June. Number 39. Mr. Prakash Shetty S.
Respondent bank, my lord.
Mr. Prakash Shetty.
Ready to have it after vacation.
After vacation.
Please.
I have a date may be fixed, my lord.
1st July.
1st July.
Obliged.
Much of
Number 42 urgent. Number 43. Mr.
I appear for
Padmanabha.
complainant in this case, my lord. My lord, order, my lord, page 7, page 19, my
This
lord.
pertain to Act 7, Lord, covered by the judgment of this one.
Matter pending before the division bench now.
Yes,
Yes, my lord. Refixation has to be done now.
Lordship was pleased to hold that there is no willful disobedience. In para 3.
That was contempt matter.
Para 7, my lord. Yes, my lord.
This is also
Similar
contempt.
matter.
Similar matter, contempt.
What we have said, other bench. That is considered open of these matters.
So then this is going to be disclosed.
Yes, it has, in terms of this, it goes.
My lord, it may be
Out of same
giving
order.
with
Same order.
liberty. My lord, liberty may be given.
Contempt, this contempt petition, which arises of the order, which arises out of order dated so and so, dated 31st January 23, on a single judge, passed in writ petition number 7/24/22. Same order was
Revival,
considered.
liberty for revival. my
Same
lord.
order was considered in contempt, civil
So
contempt
and so.
petition number 106/23,
Yes.
in which the division bench passed the following order and quote the entire order. So the present proceedings are disposed of in terms of the aforesaid order.
Revival,
Is disposed
liberty
of
may be
in
given to revival after disposal of writ appeal, my lord.
This bench.
Number 44.
This bench of this court passed the same.
Yes.
44. Mr. Neil Bruce, party person.
Your Lordship, I appear for this as party in person. The Tahsildar has not issued an EWS circuit despite this court's order, and it's been more than a year right now, Your Lordship. The learned single judge had ordered to issue the EWS circuit within 1 week.
Notice is issued or not? Please you notice.
Notice has to go.
Notice also had been issued by the previous bench, Your Lordship.
No, where is this?
The government advocate had accepted it last time.
No, there is
No,
such
no order.
No order.
Notice has to be issued. No order.
18th June.
Your Lordship, if it may be done before vacation or during the vacation, Your Lordship. Because the college for me starts on July 1st and I need to provide all the documents before July.
Let's start in July.
Yes.
Then immediately on reopening, we'll do that. 29th May.
Yes. Thank you.
In the meanwhile, you comply with office objections.
Your Lordship, the office objections raised, one of them was about respondent 3. Respondent 3 is a necessary party, so I cannot comply with that objection because I've served the respondent 3 also notice, Your Lordship. Because the Tahsildar was not complying, so I approached the Deputy Commissioner for this.
These objections are dispensed with for the time being, since the matter relates to the admission of the student.
Obliged.
But we will require you to comply with it.
Number 45.
Appearing for the complainant, my lord, I had filed a
45.
memo for withdrawal of the IA number 1, my lord. This was a contempt matter.
Yeah, you don't press.
No, not pressing. I had filed it on December, my lord.
45. Which IA not present?
IA 1.
IA number 1 is not pressed by learned advocate Ms. So and so and so. Accordingly, it is dismissed as not pressed.
Much.
It was for recalling of the order.
Yes, that is dismissed.
Number 46. Reshu Baba Mishra. 46.
Service to be awaited.
Yes.
After vacation, 25th of June.
Number 47. Lakshmi Yasrola.
May I please, Your Lordship.
PIL regarding
On the last
public
occasion, on the last occasion, the court had recorded the submission of the public relations officer of the Karnataka Legal Services Authority, that they will monitor once the tender is finalized.
Then let it be after vacation.
After vacation.
After 13th or 14th June.
14 June, please.
14 June, yes.
Grateful.
Your Lordship, serial number 44, just one thing, in that the honor fix has been changed, Your Lordship.
Your honorifics, but
Yes.
you have written Mr. there. I observed.
When I filed the case, it was Mr. Now it is legally Miss, Your Lordship.
Let us see on the next date, we will see, just mention it.
Thank you.
This is number 48, Mr. Vijay Kumar. 48.
Lord, I appear for the 32nd respondent, Lord. This is a PIL. Lord, kindly have a look at the prayer, Lord. Prayer is for the authorities to produce records before this honorable court. Lord, it's in effect. He's, Lord, treating this petition as an RTI application, seeking
After
the records.
Petitioner is not there after vacation.
Right.
Number 49,
Appear for the appellant, my
Satish
lord.
Bhandari.
The respondent.
Notice has been taken to R2 to R9, respondent 9.
Paper
Substitute
publication.
sub-
Paper publication,
Yeah.
maybe accepted.
Vijayawani,
Service of notice by substituted mode is accepted, and service in respect of R4, R2, R4 to R6 and R9 is had sufficient published.
kindly extend the interior model.
Sir, what is that?
Extend or to. We'll take up after vacation, but we'll extend the
Date may
extend
be
or
fixed,
to
my lord.
18th of June, interim relief order.
Appeal is admitted.
Appeal is admitted. Interim order is also granted to be extended.
Yes, my lord.
Also filed vacating stay, date
Hello?
may be.
So interim order shall continue till further order.
My lord, one submission, my lord. Regarding vacating stay, they have filed one IA, but R1 has entered a caveat in this honorable court.
After hearing him, interim
Yeah,
order is
yes,
passed.
my lord. So,
Point
stay
out
is
on-
not maintainable, my lord.
Let us see.
Number 50,
Obelisk.
Mr. M.
Hearing
Shivaprakash.
for Respondents 1 to 5, my lord.
Appearing for appellant, my lord.
My lord, on 21st February 2024, my lord, I filed an affidavit of the Deputy Director of Public Instructions.
No urgency.
Yes. This is a PI.
No, regular.
No urgency, 25th of June.
I6.
Lord's kind permission. Serial number 72. I am the petitioner party in person. That the CET examinations were held last week, my lord. The results may be announced anytime. I am only seeking for a direction where I have filed an IA that this 5% seats which are now being sold, it's a scam, my lord, running into the hundreds of crores. On that IA, it should be offered as government seats. If it can be listed on Wednesday on my IA, my lord. That is all my request, nothing more than that. On my Wednesday, my lord, I had made the same request last time also, my lord.
You move learned vacation, Judge.
This is listed for hearing. That's why, my lord, if there is an observation that it should be listed for IA for hearing, then, my lord, I'll move the vacation bench also.
Vacation.
Please, but let this be that it should be listed for my IA hearing. Hearing on IA.
Learned party in person is not precluded from moving the learned vacation, Judge, provided he could satisfy the urgency in the matter before learned vacation bench.
But on IA for hearing.
Yes, IA much. This is in IA only.
No, it is in the final hearing list. Now it is in the final hearing list. That's
Then
why,
you
my
can move learned vacation.
lord, may have it on Wednesday, my lord, because
Time will be left. Otherwise, we would have taken. No time is left. Yes.
your lordship may then have it immediately after vacation, my lord.
At the request of learned party in person, stand over to
29th or 30th, my lord.
5th of June.
For hearing on IA, my lord. I would request at least now let it be listed for hearing.
All matters for hearing only.
No, this is specifically in the final hearing list. It does not reach, my lord. For the last 6 occasions, it has not reached. That's why I'm.
Vacation.
With your lordship's kindly.
4050.
Now, serial number 30 was disposed of on my submission that the entry in column number 11 of RTC has been entered. But The direction is to enter OS number. They have entered the RSA number, my lord.
RSA is still pending.
RSA, I do not know, my lord, because
It is different for my lord.
now the complainant counsel informed me.
Called serial number?
13, my lord. My apologies, my lord.
So some order is passed in wrong manner.
30. After vacation, my lord. I'll seek instruction and I'll file complaint.
3rd of June. Yes.
Matter continuing. 51.
51.
Called out 51, meanwhile, he made a submission. Please. Lordship, in seal number 51.
5th of. His matter?
There interim
that
order
is-
is there.
In this, your lordship, there was a not to precipitate order. Despite that order being
51?
passed, your lordship, they have in fact now sought for initiation of continuation of these proceedings to go into the matter, your lordship. May I just pass on these memos, your lordship? Just put off his. Lordship may kindly see.
Yes, sister, but they are still violating. Are they violating the interim order?
Please. Please, your lordship, I passed on these memos, your lordship.
Why, brother?
We haven't got copies, man, I don't know what.
Or even when there is an interim order, still you want to precipitate the matter?
Your lordship, I've filed a translated copy also, your lordship. The interim order is dated 12/1. 12th of January, your lordship passed an interim order not to precipitate. On 26/3, they issue this, your lordship. In relation to the above matter by the order of the government in reference to number 1, Karnataka State Warehousing Corporation is interested and ordered the Lokayukta to conduct an investigation of the entire case in order to take action.
Lokayukta is
against-
also party.
Yes.
Why are you precipitating a matter even when there is a bench order?
I'll seek instruction. I'm not sure, my lord, what
Ah.
is transpired. I'll seek instruction.
Your lordship, one more.
Register may remain present.
Yes.
You are a Lokayukta and violating code.
I'll seek instruction.
So it is
Not-
Lordship, one more aspect, your lordship. He has been transferred, that is this first petitioner who had nothing to do in this entire matter. He's been transferred without any post and is facing the ignominy of the embarrassment as a top IAS officer having.
Only thing, that's a different cause of action.
Your lordship,
In
no,
which it
he's
was not like
transferred, your lordship, without posting after your lordship's interim order.
That is that is only a transfer and incidence of service. But this other things, they are not supposed to precipitate. If you disobey
Yes,
first
your
orders,
lordship- your
the
lordship,
order
sir.
of the first court.
Your lordships are right. Absolutely, my lord. No doubt about that. But I will just seek instruction. No doubt, my lord. I absolutely.
9. 29.
Great.
29.
While interim order is operating in the petition, a complaint was made by learned advocate for the appellant that the respondent number 2 office, respondent 1 office, respondent 2 office, 2 office, 3 office has been precipitating the matter by not obeying the interim order. Full stop. In that view, seeking explanation from the council appearing for number 3, from a stand over to
Yes.
the 9th of May.
Please, please. Obliged.
You better file IA or something.
I shall do that.
What kind of
I shall do that.
violation is this?
Please, I shall do that.
Interim order shall continue to operate.
Please, obliged. Your lordship, even the transfer, if it was regular process, I would understand. Without any
Sir, but
posting,
which day?
they're extremely
29.
humiliated by this whole process, your lordship. 29th, of course, I shall. Obliged.
Fifty-two,
my lords.
Serial number 53, review petition was filed. In that, there was a direction to enter the name of the first respondent. Thereafter, they have filed a contempt petition because I'm not a party to any of the proceedings. Now,
Where is the urgency?
may I make one submission? But now one more contempt has been filed before the South Court CC 404/2024. In that, they are insisting for to effect mutation in their name. Now, government name is there, my lord. So I have filed an application not to change the name of the entry in the revenue records, my lord. It can wait.
19.
My lords, serial number.
Lords,
Serial
my
number.
lords.
My lords, date may be fixed, my lords.
Date will be given in all.
My lords, one submission, my lords.